We've got several matters on for consideration. I want to make the announcement we're probably going to hold Senate Bill 129 as the last bill for consideration, because we have a number of people back and forth with other committees trying to get things resolved. We've got 3 other measures that we'll consider, and we'll start out with Senator Kirk's bill. Senator Kirk, come up and have a seat. Join us. We're glad to have you with us. I think it's the first time you've been with us.
Yes, sir. Thank you, Mr. Chair.
Glad to see you again.
Thank you. It's good to be with you.
We're going to do Senate Bill 34, LC 296647S. Do you have a copy of the bill, Senator?
I do.
We'll let you present to us and tell us about your proposal.
Ladies and gentlemen, this bill would allow, it's an extension of the Good Samaritan bill, Good Samaritan law rather, and this would allow anyone who sees, any citizen who sees a child in a locked vehicle left in a car seat to break and enter into that vehicle to render aid. What the Good Samaritan law has not addressed in the past is the rescue portion of this, so we cover that in what we added here in Section 1. So I would ask for your favorable consideration of this bill, and I'm open for any questions.
All right. Do we have questions from members of the committee to Senator Kirk? Thank you. We'll wait a second. Do we have anyone else in the audience who wishes to speak to Senate Bill 34? If not, we will close all further public comment. The bill is now in the breast of the committee. If there's any discussion among committee members, if there's none, the chair will entertain a motion.
Due pass, Mr. Chairman.
Motion is due pass and seconded. Any discussion on the motion? Any proposed amendments? There being no amendments proposed, the chair will call the main question, which is due pass to Senate Bill 34. Is this a committee substitute? As a committee substitute. Thank you. All in favor signify by saying aye. Aye. Opposed, like sign. Motion carries. Thank you, Senator.
Thank you, Mr. Chair. Thank you, committee.
Is Senator Miller here? Is he? Or Senator Jones? Somebody's going to present? Pardon me. Yeah. Maybe he's out in the hall. See if Senator Jones is out there for us, please, sir. Yeah, that's right. No sign of him. Who took your chair? Any sign of him? No sign. Okay, we don't have Senator Miller either.
It's Butch Miller, not
Butch, yeah.
I think they're outside. Did someone ask
Senator Butch Miller.
the group for SB 138?
Yeah, the Senate bill, governor's bill on child welfare reform. Yeah. There we are.
Mr. Chairman?
You are up.
Great.
I've got you. Come on in. You sit close with him too. All right. Mr. Comer, good to have you with us.
Thanks, sir.
You're here on Senate Bill 138,
That's correct.
and we're looking at LC 296639S. Is that correct?
Yes, ma'am. Yes, sir. That's it.
All right. Why don't you present your bill to us, if you would.
Well, Mr. Chairman, we had a pretty substantial hearing a couple days ago, and since then,
council has made some changes that are mostly technical and a few substantive changes. So let me just run through that. You'll see on page 3 of the bill some changes where there's references to the department, and we've added in the words "of the department" on line 37 and line 58. We've also added in "of the department" after the words Division of Family and Children's Services. Similar change, same change again at line 79, line 81, and then in line 85 we've changed the word "office" to the words "advisory board."
What line was that? I'm sorry.
Line 85.
85.
Am I? Then line 96, we've struck through 1994 and added the 2015.
All right.
On line 97, we struck through the capitalized word "vacancies," and I'm sorry, we've struck through vacancies there where it was on the line twice. Is that correct?
What
Am I
bill
looking at the
number are you
wrong?
looking at? 6639. Yeah. We have
I apologize, Mr. Chairman. I've got
give
the
you a
wrong.
better-
Thank you.
better copy.
Would help if I had the right document. I
Up-to-date copy. We do
apologize.
with some changes made.
Okay, let me get back over here.
All right. So I kept losing the line. You saying line number? I couldn't find where we were.
Okay. Let me get.
Yeah, you need to get
My-
oriented with
myself
from your
to the
old
right
bill.
line.
I'm sure.
Mr. Chairman, would it be appropriate to suspend, let you go on to something else? Let me come back if you have something else on the committee.
Hold on. We got one other bill that will be considered before we go to Senate Bill 129. That's going to take a while.
Okay.
I don't think we got a real problem. I think you can get Ms. Travis. She stepped out all of a sudden to give us some guidance also where you are looking to have specific changes made. She's usually a pretty good guide for that.
Actually, Ashley Fielding from the department is here,
All
and
right.
she can help us with this. Why
Why don't you go, Mike?
Yes, sir.
Ms. Travis, you can help them on where we've made changes from the bill that we looked at the first time around. You got if your copy show the changes.
My copy of the changes upstairs, and I can probably, if you have this prepared.
That's super.
Yeah, the red line. Where did you left off?
He was just beginning down to line 97, page 4 now.
All right, so the difference between what was on the previous version and what is here now on lines 95 and 97. Before, you'll remember the gentleman that came in that spoke that wanted to be able to retain the folks that were on the board presently.
Right.
So the change was to restore the language that was stricken and just change the date from 1994 to 2015.
Okay. That we did.
Moving to 49-3-6, which is in the bottom of section 3. And I don't know if we started with department is defined for the entire title. And so a lot of these changes were just, and so that means that you always use the lowercase d, department. You don't have to
Right.
say Department of Human Services. So those changes were made repeat in a number of locations. Specifically, the difference would have been in with respect to,
So actually we're using division now as opposed to department, are we not, throughout the bill? Division of Family and Children's Services?
right, but of the department.
Of the
So,
department, yeah, the
the-
department being the Department of Human Resources, Human Services.
Yeah, right. I'm sorry. So I'm looking at line 186.
All right.
It's of the department, and what it said before was of the Department of Human Services.
Gotcha. All right.
And twice in that section. Also in section 6 of the bill, in subparagraph H, at line 351. I'm sorry.
351.
I'm sorry.
Nope.
At line 347.
Okay.
It used to say custody of the Department of Human Services, but because it's defined, we could just make it say department.
All right.
Moving to section 7, which is the liability section. The difference is, again,
Right.
changing Department of Human Services on line 449 to just being department.
Correct.
And also the word civil was inserted before the word liability to indicate that we're only dealing with civil liability.
All right.
Not criminal responsibility.
Correct.
Moving on to section 9 of the bill. In subsection B at line 494, Department of Human Services was changed to department. That same
Right.
change was made on line, in that same paragraph. 498, thank you. And at the, on line 506.
506.
Yes, sir.
All right.
In section 10, in paragraph 2, this was a correction to current law, which had department wrong, at line 550.
Right.
Then we move to section 11 of the bill, which has to do with registry. And there were quite a few changes from what was there before and to what is there now, but all of them
The
minor.
registry, yeah.
And many of you that have worked with me have seen my little color charts where I color diagram all the words, and then when there's repetition within the words, then we're circular and they don't make sense, we make changes. So specifically looking at line 638, after the words substantiated cases, it said of child abuse.
Yes.
But child abuse is within the words of substantiated cases, so that was superfluous. Yeah, thank you.
Unnecessary.
I like that better. So we took that out. Within the definition of online 652, child abuse registry, we didn't send the reader back to looking at a code section because that's circular. We took
Right.
that out. On paragraph 8, after the word convicted, we took out of a child abuse crime because when you look at the words of convicted on line 655, you see child abuse crime is within the definition.
Right.
Within division, we changed department on line 663 to lowercase d.
Yep.
Moving on to 495181. After substantiated, we took out of child abuse.
What line are you looking
on
at?
paragraph 1, line 678. On line 680, it used to say persons convicted of child abuse, blah, 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 but convicted child abusers is an easier way to say it and a defined term, so we changed that around. And subsection B, substantiated cases, line 684, we took out of child abuse on that line, and also
Child abuser.
after on 685, the same change. The same change after of substantiated would have been at the end of line 689.
Gotcha.
Moving on to the information to include in the registry, the idea, what used to say on line 695, it said, and the birth date of the child's parents, custodian, or caretaker.
Just saying
if
birthday
known.
parents.
And the problem with that is child just means somebody under the age of 18. We really mean the child that was alleged to have been abused, so we added that phrasing in. On line 703, upon receipt of a sentence for a convicted child abuser, again, we just changed the words there. It said a person convicted of child abuse to use the consistent
Right.
phrase. The change that I described about the child language is also made in paragraph 4.
Gotcha.
Say, to say that. On line 714, after substantiated case, we took out child abuse again, of child abuse. Very few, in deep in here, where are we? In
I thought they changed that.
185, in
Health and
subsection C,
What's health?
there were some minor changes of changing that person to his or her in 2 locations, and substantiated on line 867 was changed. In 586, the catchphrase relating to open records was removed in subsection A at line 875 as unnecessary.
Right.
In B, the use of the information by the district attorney for any offense which constitutes or results from a child abuse was taken out because the catchphrase at the end is if it's otherwise admissible. So it doesn't matter if it's just in that case or another case. If it's admissible evidence, it's admissible evidence. In paragraph 2 at line 887, relating to open records was taken out. And 49.5.187, the phrase was first of all cleaned up to say civil liability or criminal responsibility, and there was a phrase after information that repeated the language above it was taken out for redundancy.
Okay.
Moving on to the next section, which is
13.
when we get into Title 15, the word relative is defined for Title 15, Chapter 11, as any person that's related by blood or marriage. So looking at section 13 of your bill, in paragraph 14, where we say, looking at,
Fit relative.
yeah, looking at, I'm sorry, I'm on page 27 of the bill, documentation, fit and willing relative. It used to say including adult siblings. That was removed because it's included in the definition of relative. And section 15 of the bill,
All right.
at church, school, looking at line 876, it says now approved by DFACS. Before it said approved by the Division of Family and Children's Services.
976.
Yes, sir.
976, yes, sir.
Yeah. Okay.
It now says DFACS. It used to say Division of Family and Children's
Right.
Services.
Okay.
DFACS is defined for the chapter. Looking at section 17 in paragraph 9, the including adult siblings was again removed after fit and willing relative on line 1018. In subsection C of that section on line 1034, it used to say permanency living arrangement, and the word is permanent living arrangement, so that was just a spelling change, and that was it, sir.
So I'll take any questions at this time.
Now, what we want to hear, I think, quickly but briefly, a little bit, is history about what we're doing here with the bill, because there's some people who may be on the committee that were not here at the last meeting. So the purpose behind Senate Bill 138 is to, by statute, bring into force several of the matters that came out of the study commission that was set up by the governor to review all of the DFACS provisions to see how, under what circumstances we're providing care for dependent children in this state through the Department of Family and Children's Services, correct?
Yes, sir, that's correct.
And so a lot of the stuff that, a lot of the recommendations really address policy issues that are done strictly through the department, but these are the things that had to be addressed because statute has covered them in the past and still does. And one of the things we did do that I speak to personally was we set up a better, what we think is a better form of communication between the local boards, which are down in every county, with every county having a board, and then that board has members who will serve on an advisory board to the district level, and then from the district level you also have a state level board, which is also an advisory body that would help the director in implementing and preparing what would be potential rules, regulations, and policies, some of which would be implemented by the director, some of which would have to go to the department for actual implementation by adoption of the board of the Department of Human Services, correct?
Correct.
Okay. Anything else you want to add to it?
No, sir, I think you've covered it pretty well.
There you go.
There are also some sections that were required by federal law. The Preventing Sex Trafficking and Strengthening Families Act had some requirements in order for the department to secure its Title IV funding.
All right.
Those are included in this provision as well.
Any questions of members of the committee? And Mr. Weldon.
Thank you, Mr. Chairman. To the sponsor of the bill, I won't say the author of the bill. You know, Ms. Fielding has been very kind in working with me on this, and I appreciate the work we've discussed on this. On line 302, it's number 16. Reasonable and prudent parent standard means a standard characterized by careful and sensible parental decisions that maintain the health, safety, and best interest of a child, while at the same time encouraging emotional and developmental growth of the child that a caregiver shall use when determining whether to allow a child or in foster care under the responsibility of the department to participate in extracurricular activities. I was just wondering where that language was developed from. I probably wouldn't come up with that right off the top of my head. I was just curious about where that might have.
Yes, sir. That came from the Preventing Sex Trafficking and Strengthening Families Act. A large part of that legislation was to ensure that children who were in foster care were able to participate in age and developmentally appropriate activities. I think the example that was used earlier this week was a game of pickup basketball. To have the freedom to, maybe spend the night at a friend's house, something that would be appropriate for another child their age.
And presently, the department precludes that type of activity because of the concern for a child to be able to participate in an activity where there's a perceived greater risk of harming himself or spending the night with somebody and then something bad happening, and then the department's liable.
There is a more restrictive environment today. Yes, sir. Our Chief Legal Counsel, Vivian Egan, could kind of fill you in a little bit more if you'd like some more information on that.
Well, I would like to know if that was developed from Georgia case law or where that came from. I want to know.
You want to take that mic on the end there?
I believe it was straight from the Act.
Okay.
Let you use that.
The definition comes straight out of the federal act. We're required to utilize that standard in order to get our 4E funding. I think it is an appropriate standard because I think children, who are in foster care ought to have similar experiences to those who are not. But that's where the language came from.
Okay. Well, Mr. Chairman,
sure.
I got another question too. And then over in section 7, on page 13, beginning at line 448, I think, Ms. Fielding, I think we discussed the issues related to this, but after we discussed some concerns in a subcommittee meeting, this provision provides immunity from civil liability as a result of a caregiver's approval for participation of a child in activities like you just described, the pickup basketball game. And I'm thinking of other extracurricular activities that would be included like that, rec football, rec baseball, you name it, karate,
Boy
whatever.
Scouts, camping trip.
Right, those kind of things. And my concern in this is the immunity that's happening here. This says, or child welfare agency or other entity under contract with the department shall be immune from civil liability as a result of a caregiver's approval of participation of a child in whatever activity, provided so long as the caregiver acts in accordance with the reasonable, prudent parent standard, which I think that's a reference to line 302 through 307. Is that right?
It
The
is
definition.
a reference to the previous
Okay.
definition of reasonable and prudent parent standard. This bill also provides for training of foster parents on that standard. The department, as a result of that federal law, must train parents on that standard so that they're sure of what the parameters are there.
Okay. And I know, Ms. Fielding, we had discussed that this was necessary in order to continue with the funding and to fit that bill.
Yes, sir.
In my reading of the requirements that I think you and I discussed, it didn't I didn't understand it to specifically say shall be immune or indicate that it has to be an immunity. As long as there's a defense and the standard is provided, like is provided in line 302 through 307, and I'm, I guess I have a proclivity to stay away from immunity for agencies, entities under contract with the department. I think I'm comfortable with a foster parent or caregiver that has a foster child in their care, as long as they act with reasonable parent standard. I still don't like immunity because I think it's something that the jury needs to decide, but I'm more comfortable with them having that kind of immunity than I am with an entity or other, with a welfare agency or entity under contract with the department. They can exercise influence, and even though over the foster parent or over the situation, and even though the foster parent, based on what they knew at that time, acted in accordance with the reasonable parent standard, there still could be some issues that come up, and maybe it's something that happens in every child's life, whether they're a foster child or not. That gives me concern, and it frankly gives me pause about that. And if you could just comment as to how what went into the consideration of that, I'd appreciate it.
Yes, sir. I certainly understand the concern you might have there. The Preventing Sex Trafficking and Strengthening Families Act, specifically in Section 111B, speaks to the department needing to address liability with regard to the reasonable and prudent parent standard. The department, about 45% of the children who are in state custody are placed with a private child welfare provider. In those cases, we may be contracting with an agency that then recruits and supports foster parents on the agency's behalf. This was drafted to cover those agencies. I'll ask Vivian if she would to sort of fill in on the entity aspect of that as well.
We contract with both CPAs and CCIs to provide residential care for children. And what happens is when something happens and there's a lawsuit, they name the CCI or the CPA as a defendant. So just providing protection for the foster parent will not allow the full implementation of the standard, because we want the children in foster care to be able to have normalizing experiences. And in order for them to do that, not only does the foster parent have to be protected, but also the entity, because the entity, the CCI, the CPA, is going to be interested also in protecting their liability. We don't want that feeling of unease about the standard to keep the standard from being carried out. And that's the reason for that, because the defendant in the lawsuit will be the CPA or the CCI.
Representative Kuma.
Thank you, Mr. Chairman. To echo, the policy position, regardless of whatever the federal standard may be, the policy position is to, as counsel just stated, encourage the normalization of the experience for a foster care child so that they'll have as close to a normal family experience that any other child would have. But also, I would point out that the immunity is, number one, narrowly tailored to a specific circumstance, and since it's in derogation of common law, it's going to be strictly construed by the courts. So to the extent there is immunity, it is narrowly tailored and will be strictly construed and will not be open for a broad expansion by the courts in other areas.
Representative Lawler, did you want to be recognized? I was going to make a comment similar to Representative Coomer's. And I really can't figure out in my own mind, when you have a reasonable prudent standard and defined as it is here, how the contracting agent or the family foster care parent is going to be in a different posture than the child going to the next door neighbor, and the next door neighbor having a pickup basketball game with your own child. I think the narrowness of the standard, the narrowness of the language, gives me comfort. And it also prevents an agent's, a contractor coming in and saying, trying to contract with some special rules about liability.
Mm-hmm.
We're only going to be liable and blah, blah, blah. This protects the state from having to deal with different standards with contractors who are wishing to contract with the state who may wish to have some other standard. So that I see that benefit there. I see the benefit of encouraging contractors and family daycare to offer normalized and not to be normalized activities and not to be too restrictive.
Mr. Chairman, if I could briefly.
Yes.
Thank you, Representative Alva. I think you bring up an excellent point there. I have an amendment that I'd offer, but I think in light of the discussion, I'm persuaded that the standard is probably, I hope, bottled up and sufficient. The other issue that I think that I'd like to address is, what about those contracts that we have out there now with these care providers that have a limitation on the liability of an agency or entity that is involved with a foster care child? How would that, I know we can't go back and change that, but prospectively, other contracts that the state has, there needs to not be the standard doesn't need to go below the standard we have here. And if we could put a provision in there that addresses that, I think I'd be a little more comfortable with that. I know we got good folks that are looking after these contracts and examining those. If we could put a provision that says that any provision of any agreement that diminishes the standard of care.
Where are you, Mr. Weldon?
Well, I'm in line 448 through 452. And maybe I'll give me a minute. I may be able to put a.
Well, we're going to get moving on a motion in a moment.
Okay.
Further discussion? Any further discussion? Anyone else in the audience wish to address the committee on Senate Bill 138? All right, we'll close off further public comment. The bill is now in the breast of the committee. The chair will recognize Ms. Oliver.
Move to pass, Mr. Chairman. Second.
We have a motion to pass is seconded. Any discussion on the motion? Any amendments? Mr. Weldon.
Thank you, Mr. Chairman. I have a provision on, or an amendment I'd like to offer after.
Tell me where you are first.
On line 452.
452.
After the period, strike the quote marks and insert a new sentence there that would read as follows: any provision of any agreement that, I guess that's any agreement with a welfare agency or other entity under contract with the state, with the department, excuse me, shall not diminish the standard of care provided herein.
And for the chair's benefit, read it back and then explain what the purpose of the amendment will be.
Okay, on line 452, after the period following the word standard, strike the close quote marks and insert a new sentence that would read as follows. Any provision of any agreement with a welfare agency or other entity under contract with the state that diminishes the standard of care shall not diminish the standard of care.
Just read without making the mistake on Ken.
I don't know if I can do that, Mr. Chairman.
It helps understand a little bit more
Okay.
about it.
All right. Any provision of any agreement between a child welfare agency or other entity and the state shall not diminish the standard of care provided herein.
All right, you mentioned state. You wanted to change that one time to
Did-
department.
Exactly. I made another mistake.
Tell me what your proposed motion is intended to do or correct.
I don't want the standard of care for any welfare agency or other entity, whatever that is in contract, that contracts with the state to care for these children, just like was identified by counsel for the department, to have any lower standard of care that they could insert in their contract. And I don't want that to be diminished because we got a lot of people in the line of that are looking at these children and have liability for these children. And I want to make sure they're all on the same standard and they're all under the same umbrella.
All right, first of all, do we have a second to the proposed Weldon amendment?
I'll second it.
It's been seconded. Have discussion on the amendment.
Mr. Chairman,
All right, first let me recognize Ms. Oliver.
Thinking about whether or not that's a useful, I'm just thinking useful amendment, but the term welfare agency or other entity, maybe I'm offering this for your consideration, and then I'll, if you wish, make a substitute.
Okay.
Maybe better defined by caregiver on page 7, line 221, because I don't think we have a definition of welfare agency or entity that would be a contracting entity. Caregiver means that either foster care parent or has been placed in a designated official for a child care institution, so we have a definition of who you may be wanting to cover. The reason I might support your amendment, if it's clear about who we're designating as the might be, is that it would be a safety net for any other negotiation, although the safety net really should be contained in lines 302 and 307.
You have a question down here. Who's that? Mr. Jacobs?
Yeah, I want to
Comment?
hear a little bit more about. I think Representative Oliver's approach makes better sense in terms of the wording of the amendment and tying it up with the defined terms. I would also suggest that at the end, rather than herein, because the standard's right here in the code section, we should say provided in this code section.
Okay. Definitely.
I'm probably, before we get to a vote on this,
I'll accept that Travis
let me finish,
amendment.
Mr. Weldon. Probably before we get to a vote on this, I'm going to suspend this bill and hear another bill while y'all work up a specific proposed amendment. But let me first hear from the sponsor of the bill, Mr. Comer, and his parties. Excuse me, I got the wrong one there. Gotcha.
thank you, Mr. Chairman. Conceptually, we're okay with the intent of the amendment that's offered. I think, sort of following on the same point that Representative Oliver had in looking at the specific language of the amendment, I think when you refer to a child welfare agency, that is the department. That would not be so obviously when you look at the line 448 or other entity under contract with the department, the under contract with the department qualifies other entity. It does not qualify child welfare agency. So I think what you'd want to say is any provision of any agreement between any entity under contract with the department shall not diminish the standard of care provided herein. Because the way I read it, child welfare agency is the department.
All right. Mr. Weldon?
Thank you, Mr. Chairman. Well, then, why don't we just take or child welfare agency out and just put department?
I'm not sure if of course, the department is the Health and Human Services, not the division. The division's DFACS. The welfare agency we're talking about really is not the department, but the division, is it not?
That's correct. That's correct, Mr. Chairman. But to the same point, the child welfare agency would not be in contract with the department. The child welfare agency is a division of the department.
What I'm going to do, if you want to pursue your amendment, Mr. Weldon, I'm going to suspend further consideration on Senate Bill 138 and allow you and Ms. Travis and Ms. Oliver to sit down and try to pull together some language, and certainly y'all can participate. Did you have a question, Ms. Stevens?
Mr. Chair, I did have a question. I'm going to waive until the final language.
All right.
Mr. Chairman.
Yes, sir.
If I may, as we're getting on closer to the end of this session, I would commit to Mr. Weldon that if we get an opportunity to move this bill forward to rules, that we'd be amenable to an amendment in rules if that's acceptable to the chair.
Not really.
Okay.
We prefer it, and it won't take too long. I'm not saying we're not going to consider the bill this afternoon. We're going to consider it.
Okay.
It's just give them about 10 minutes to sit back there and come up with some acceptable language, and I think Ms. Travis, with her great talent, can help guide that.
Thank you, Mr.
So no pressure. Never. She always comes through for us. So I will suspend consideration on Senate Bill 138, and we're going to take up the bill that Mr. Senator Jones, you're here. Thank you. You've got a great piece of legislation here dealing with the state symbols. We'll give you all of maybe 10 minutes. How's that?
I hope I don't need that long.
Right.
I apologize.
We're
I
going
was here earlier. I had rules, and y'all, if y'all understand our rules, Chairman, he likes for you to pay homage to him. So.
I understand.
But
we're going to consider Senate Bill 168, which is our copy is LC 400845. I think that may be the same one you have.
Yes, sir.
All right. Why don't you tell us about your proposal?
It's a very simple bill. I know y'all hear that a lot, but this one is. It's the old governor's mansion, which is located in Milledgeville, Georgia. We are asking on behalf of Georgia College and Department of Economic Development if we could consider the old governor's mansion, which served as the state capitol from 1838 to 1868. And house 8 governors and their families, if they could be considered as the state historic house. Currently, the governor's mansion is used by Georgia College and State University as a event center. They do paid tours there. They hold different events for the colleges, and it's a real jewel for the state of Georgia, and we would like for it to have that consideration.
All right.
And I'll accept any questions.
Any questions from members of the committee? I will comment. I've visited there a number of years back when we had the one-day session down there, which was like 2002, when they did the 150th anniversary.
It could have been, sir, but that was before my time. But it probably
Wasn't that long ago. Wasn't that long ago.
I was still running the streets of Athens at that time.
Yeah.
So.
But anyways, they use it as a museum mostly now, do they not? As the mansion's used mostly as a museum today.
Sir. It is. Yes, sir.
Okay, we'll continue that use.
Yes, sir. It is.
All right.
It sure does.
Any further questions of the presenter? If not, is anyone else in the audience wish to speak on Senate Bill 168? If not, we will close off further public comment, and the bill is now in the breast of the committee. Do we have a motion? Been moved and seconded. Do pass. Any discussion on the motion? Any amendments? There being none, the chair will call the main question, which is the motion of do pass of Senate Bill 168 as presented to us. All in favor signify by saying aye. Aye. Opposed, like sign. Motion carries. Thank you.
Thank you, Mr. Chairman, and thank you, members of the committee.
Thank you. We're going to take about 5 more minute break while we're waiting for the other group to come back in on the drafting of that language. So if you wish to stretch your legs, we will start at 3:05, which was suspended on Senate Bill 138. I think we're going to have a draft of an amendment. Let's take a look, if we can, line 448 to 452. And this is under Section 7. Mr. Weldon, we'll let you state what your amendment's going to be. You got one? I'll give you mine. Here we go. All right. Chair recognizes Mr. Weldon.
Well, thank you, Mr. Chairman. Ms. Fielding's going to help me make sure I read this amendment right. I propose I make an amendment to this is SB 138 296639S.
I'm saying you're striking the lines 448 through 452?
Yes,
All right.
Mr. Chairman.
Inserting the language you have drafted on the
Yes,
proposal?
Sir. Yes, sir.
And let me read out loud. Any caregiver or other entity under contract with the department shall be immune from civil liability as a result of a caregiver's approval of the participation of a child who is in the custody of the department in an age or developmental appropriate activity, so long as such caregiver or other entity under contract with the department acts in accordance with the reasonable and prudent parent standard. No provision in any agreement between the department and a caregiver or an entity under contract with the department shall diminish the standard of care provided in this section, this code section. And is that agreeable to the department?
Yes, Mr. Chairman.
All right. Yeah, that's proposed amendment. Do we have a second? It's been seconded. Any discussion on the amendment? If not, the chair will call the question on the Weldon amendment. All in favor signify by saying aye. Aye. Opposed, like sign. Motion carries. Do we have any further amendments? If not, the chair will call the main question, which is a motion do pass of Senate Bill 138 as amended. It's a committee substitute. Any discussion on the motion? If not, the chair will call the main question. All in favor signify by saying aye. Aye. Opposed, like sign. Motion carries, and Senate Bill 138 goes forward. Thank all of you. It's been great deal of work, and we appreciate everybody's involvement. I'm going to this time turn over the chair of the committee to Vice Chair Fleming.
All right, let's begin on, we've done everything on the calendar, I believe, now except Senate Bill 129. So let's begin with there. Senator McCoon, you want to come on up? We have, Senator and members of the committee, several witnesses. I count 1, 2, 3, 4, 5, 6, 7, 8, 9 that have signed up to speak. I know that the chairman wanted to keep those comments within the 3 to 4 minutes range, and he asked that we go ahead and begin taking that testimony. But, Senator, I did want to give you the opportunity, since it is your bill to come forward and take the time that you see fit. As far as where we are posture-wise, several members of the committee know that this bill was in a special subcommittee yesterday. About half the committee was on that special subcommittee. There were several changes made to a substitute that the chairman brought in. You have that with you in your folder now. And, of course, Senator McComb was with us all day yesterday. So, Senator, we'll go ahead and give you the time that you need to introduce the legislation, specifically to the members of the committee that were not here yesterday. So welcome and thank you for bringing the bill to us.
Thank you, Mr. Chairman. What I'd like to do, and not to belabor it for those who serve on the subcommittee, but I do want to kind of go through a little bit of the procedural history and then the substitute that you have before you. This substitute is Senate Bill 129, the Georgia Religious Freedom Restoration Act. What does it seek to do? What it seeks to do is to restore the right of free exercise to a strict scrutiny standard, as other fundamental constitutional rights have currently under Georgia law: the right of free speech, the right of free press, the right of assembly, and so forth. The history on this is from 1963. The Sherbert decision, the U.S. Supreme Court found that strict scrutiny should apply to free exercise challenges of government actions. That strict scrutiny standard remained in place until 1990. In 1990, the U.S. Supreme Court, in a case called Employment Division versus Smith, vacated the strict scrutiny standard, went to a rational basis standard for free exercise claims. And Congress reacted fairly quickly, and I think a handful of times they've acted throughout the nation's history, to instruct courts to go back to the strict scrutiny standard. They did that in 1993 with the passage of the Federal Religious Freedom Restoration Act. And so you may ask, if there's federal legislation, then why am I before you in 2015 with Senate Bill 129? The answer to that question is in 1997, in the city of Byrne versus Flores, the U.S. Supreme Court decided that while the Federal Religious Freedom Restoration Act strict scrutiny standard could apply to actions of the federal government, that it could not, that it was an impermissible use of congressional authority to extend that legal standard to state and local government action, and that states would have to decide for themselves. And so that is exactly what states have done. Today, with Governor Pence signing the Indiana Religious Freedom Restoration Act, there are now 32 states that either by judicial decision or statute have adopted substantially the language that you have before you in Senate Bill 129. So that's the history. I'll briefly go through the bill itself. First, you have the definitions. The definition of compelling governmental interest, which includes but is not limited to protecting the welfare of a child from abuse or neglect, is provided by state law. Delinquent act is defined. Exercise of religion is defined. Government is defined. I guess I'll mention a couple of the changes. In the original bill that came over, we did not define compelling governmental interest. That has been used basically by courts as a construct to perform the balancing test that we'll get to in a moment. In exercise of religion, we also included in the Senate language a reference to the Free Exercise Clause of the First Amendment to the United States Constitution. And then in the definition of government, there was some language referring to individuals acting under color of law, and I think there was some concern about that, so that was removed. Going on to page 2, the definition of penal institution and restrictive custody, I don't believe there were any changes there. The real sort of meat of the bill is between lines 34 and 40. This is codifying the strict scrutiny standard for free exercise cases, and this language mirrors the Federal Religious Freedom Restoration Act. It simply provides that if government is going to impose a substantial burden on a person's exercise of religion, that it must demonstrate that burden is in furtherance of a compelling governmental interest, and it's the least restrictive means of achieving that compelling governmental interest. The committee specified in subsection D remedies, and specifically added that a person aggrieved would be able to seek a declaratory judgment or injunctive relief against government. In section E, there's an attorney's fees provision. In F, there's language about the Religious Freedom Restoration Act not being used as a justification or defense to a criminal proceeding, but that a criminal proceeding would be stayed if there was a civil action filed under this statute. And finally, there's language regarding the fact that nothing in the code section is going to prevent prisons or correctional institutions from imposing rules that are necessary for safety and security. We also had a request from the business community for language that made it very clear that it does not create any rights by an employee against a private employer. And then what you have in as section 2, most of which is on, I believe all actually is on page 3, that is the text of House Bill 59, which has to do with the waiver of sovereign immunity. And then, section 3 is the effective language, section 4 is the repealer. And I don't know, Mr. Chairman, if it's appropriate for me to comment on any of the proposed amendments. I'm certainly happy to do that at the appropriate time.
Absolutely, go ahead.
Okay. We had this discussion in subcommittee yesterday regarding the definition of compelling governmental interest. Really, the heart of the Religious Freedom Restoration Act is to allow courts to perform a balancing test, and that balancing test is between the free exercise right of a person and the interest of the government that is compelling in nature, and whether or not they're using the least restrictive means. So I think that we certainly had a lot of discussion on our side about defining compelling governmental interest, and looked at case law, looked at other sources, decided that the best thing to do was to leave the term in there and allow Georgia judges to interpret this statute as judges in the other 30-odd jurisdictions have done. Having said that, I don't object to the language defining compelling governmental interest at lines 15 and 16 of the substitute that's before you. I would strongly object to adding this language that includes protecting persons against discrimination on any ground prohibited by federal, state, or local law. There are a number of reasons for that. I believe that, first of all, when you talk about local law, we are now going to be talking about defining religious liberty differently in every jurisdiction of local government in the state. 159 counties, I don't know how many municipalities. So the uniformity is totally gone. I think that when you add something as broad as what is before us, you really have an exception that swallows the entire rule. I believe that this language, if added to the bill, for example, would prevent a religious school from having morality clauses in their contracts with employees. I believe it would interfere with very basic fundamental religious rights, and so I would strongly oppose that amendment. And frankly, that amendment would completely undercut the purpose of the bill. The second amendment regarding the criminal proceeding, I know there was a lot of discussion in the subcommittee on that. I have no objection to that. I think that accomplishes what the subcommittee was talking about yesterday, which was balancing the possibility of someone interposing a religious defense in a frivolous way against the very real possibility that someone's what could be defined as a criminal act is in fact an extension of their religious exercise that could be vindicated in a civil action under this statute. So I think I have no objection to that amendment. And I believe there are two other amendments that I have been provided with, authored by Chairman Powell. One has to do with amending the language of House Bill 59. It references line 64 of the substitute. I have no objection to that.
Hold on 1 second. Do we all have that amendment? Pass it out. And
do you want me to hold on that?
Yeah, hold on to that.
Okay.
Let us sit about
Okay.
getting the hand just 1 second. Here's another one.
Mr. Chairman, while that's,
Yes, sir.
while that's being passed, I got a question for the Senator, if I might.
Absolutely. Is your mic on? Yes, it is.
I think it is. Senator, my first question, is with what we passed out yesterday, not any amendments.
Yes, sir.
Not anything that's being proposed today. My question has only to do with what we did yesterday. Were you, I use the term okay, or consent to, basically, were you all right with what we did yesterday?
Yes, sir.
Thank you. That's my question.
Okay. Do we have all those passed out? Representative Hall, did you have a question before we went on to the amendments about? Go ahead, state your, what are you, number what there? 4 maybe? Try that one.
And I just wanted to know how we were going to proceed. I thought Chairman Willard wanted to hear testimony for up to an hour, and I didn't know whether you wanted to have questions before or after the testimony in relation to any of the amendments or in relation to the author. What is your preference, is what I'm asking.
I think what we will do at this time is that we will allow him to give initial comments, address the amendments, and then we will allow the witnesses, and then we'll bring Senator back up.
I apologize.
No, that's okay. That's okay.
No,
I had to think this through too. And then we'll bring him back up when we get ready to consider the amendment, so he can comment on them at that time. And I think that would be a good time probably to bring him back up for questions from the committee.
So it sounds like that you would rather us hold questions until after the testimony.
I think so, unless it has bearing on something that we're going to proceed with.
No, I had a question about his comments right now, but I'm happy to wait.
Let's let this be introductory, then we'll go to the witness and we'll bring the senator back up, because we'll probably, I would, and advise the chairman when he comes back to let him give us some more comments. He may want to comment on what the witnesses said, and then we'll have a discussion with him in the committee. Thank you. Mr. Bruce, did you have a question similar to? All right.
You just made a statement. I'm just
bring your mic over to you, Mr. Bruce.
I'm trying to make sure I understand it. You made reference, and I hope I'm quoting you correctly here, that to add anything to this bill that would specifically, identify that it's not intended to discriminate would undermine the purpose of the bill. That's what you just said. And if that is the case, then that tells me that the purpose of the bill is to discriminate. That's
couldn't be further from the truth. No,
okay.
sir.
All right. Well, that's why I wanted to make sure I heard you differently.
I offered several reasons why I think that language is extremely injurious to the purpose of the bill. One of which is that no one sitting here can possibly know what the literally hundreds of jurisdictions around the state might adopt and caption an anti-discrimination ordinance. There's absolutely no way to know that, and there would be no uniformity in the law if that went forward. What I also said is that it would interfere with the ability, and one example is of religious schools that, as a matter of course, have morality clauses in their contracts with the teachers that teach in their schools to conform to the teaching of that religious institution. That's one example. I'm sure if given enough time I could come up with a lot of examples. What this committee, or what rather the special subcommittee, has heard zero examples of is the Religious Freedom Restoration Act language ever being used to defend a case of invidious discrimination. You had a former Attorney General of this state who has been hired by opponents to this legislation who is, as I understand it, researched this extensively, and he was asked by members of this committee to cite a single case, and he was unable to do so. This law at the federal level has almost 50 years of case law behind it. In the 30-plus jurisdictions around the country, there's at least over a decade of case law in most of those jurisdictions. And the problem that might be intended to solve here has never manifested itself. So I would say for all of those reasons that it would be mistaken to move forward with that amendment.
Okay. All right. And that was a comment on the amendments that I was giving you the opportunity to speak about. And there have been some others passed out. You may not have had a chance, Senator, to review them. If you have any others that you want to look at or comment on, that's fine, of course. My recommendation to the chairman when he comes back will be to bring you back after we hear the witnesses, and that may afford you time to look over those if that does you well.
Then the only other thing I would ask, Mr. Chairman, is to briefly address some of the opposition that's been out there.
Absolutely.
Very briefly. I think I have adequately covered the first argument that's been made by many of the opponents that there's some sort of license to discriminate enabled by this legislation. That's simply not the case. There are no cases to support that assertion. There's been another claim made that it is somehow going to provide someone with an opportunity to be excused from criminal conduct. Not only is there absolutely no case of that occurring, but this committee has taken action in the substitute to address that specific concern to the extent it ever did manifest itself. Third and finally, there's been this sort of nebulous argument that it could negatively impact economic interests, and that again is simply not the case. Like I said before, 32 jurisdictions around the country have this law in place. It's been in place at the federal level for 22 years. It's tested, and I appreciate the work of the subcommittee to produce a substitute that is before you. Thank you, Mr. Chairman.
Thank you, Chairman. We appreciate you being here today. If you want to move over to the side or wherever, we'll be fine, and we'll allow the witnesses to come forward right here. The first witness, Ron Fennell. Is Ron Fennell here? He's right outside the door. Representative Thomas, you want to get him? Yeah. Mm-hmm. That's Fennell. Fennell? I'm sorry. My bad. Mr. Fennell?
How are you?
Welcome.
Mr. Chairman.
Good to see you today. Thanks for coming. Please introduce yourself and tell us who you are, and I'll mention to you that I had made comments earlier that the chairman had asked me to keep comments to about 3 minutes.
Okay.
And you're welcome to speak less if you like. You don't have to take that long. But
in this room?
Somebody told me you've been here before. Former member of the House?
I've been escaped for now going on 23 years. I'm
have
trying
you
to
recovered yet?
No, I have
okay.
not.
Well,
Mrs. Oliver, where are you? You know better, don't you?
Well, please tell us who you're with and welcome. Thank you.
Good afternoon and thank you. My name is Ron Fennell, and I have the privilege now next month for 20 years to represent the Georgia Hotel and Lodging Association. And as many of you know, tourism is an important element of our state's economy. You own the Georgia World Congress Center and properties around there. It's really an important investment you've made in our industry. Our job is to fill hotel rooms and your convention center, and we appreciate the partnership that is rich, deep, and long-standing. We are challenged when we try to sell our destination by a couple of things. Number one, we don't ever have enough money to tell our story. We get around that in some way. But secondly, we have Southern hospitality. It's a charm that is an appealing part of who we are, just our makeup. And we sell that a lot as best we can, and when people come to visit, they want to come back. But thirdly, we have positioned ourselves as the hub of civil and human rights. And we have a destination tourism product that exhibits that, celebrates that, and offers the invitation and the promise that Dr. King presented to us all. And I think the opportunity to continue to offer that welcoming nature is really important. And we appreciate you taking the diligence in dealing with this issue. I will say that our industry strongly believes in supporting religious freedom. It is a key element of our democracy, and that's why it's in the Constitution, and we actually amended the Constitution to specifically refer to it. I ask you to take great care, because when we're talking to our customers, they don't understand the lawyer talk that goes on in a room like this, and it's the perception 90% of the time that either wins us the business or not. We work hard. We will continue to work hard. but we caution you to remember that the major investment that the state has in the World Congress Center and our partnership with you is at stake sometimes when the customers are asking us how welcoming is the destination, if this is a perception. So I appreciate you, Mr. Chairman, allowing us to say a word. I have with me the Executive Director of our State Hotel Association. I did want to get him on the record, Jim Sprouse. Jim?
All right, thank you. As Ron introduced me, Jim Sprouse, Executive Director of Georgia Hotel and Lodging Association.
Welcome, Jim.
Well, thank you. As an industry, we're concerned about the perception as an unwelcoming state. Every day, decision makers are selecting locations in which to do business and to live. Please don't discount the importance of that perception. Those decision makers can and have ruled out destinations just based on concerns of discrimination. There are 411,000 Georgians making their living in hospitality. Millions and millions of dollars at stake in terms of events going on in this state every day. The controversy around this bill, to me, makes it clearly evident that it should not pass. We believe there are sufficient protections in place already, making this bill unnecessary. Our reputation as an open and welcoming destination must remain clear and present in the minds of our guests and the people who choose to travel to and conduct business in our state. And I have a copy of our statement that I'm welcome, if you'll allow me to pass out. I can
Absolutely.
pass that out.
Very welcome to that. If you give it right here to Ms. Womack, she'll pass it around for you. Okay. Okay.
We'd be happy to answer any questions if that's
Sure.
appropriate, Mr. Chairman.
Sure. I have one for you. There are
Yes, sir.
31 other states who have laws similar to this. Have any of those states attempted to repeal that law because it's hurt their tourism or hotel business, to your knowledge?
Well, to my knowledge, not being a lawyer, I know that...
It's not a lawyer question.
Well, but 20 of those states have some similar legislation, I understand, and the others are enacted by other means. And to tell you the truth, we concern ourselves with when our piece of business is coming here or not. We don't, we try to compare ourselves to our competitive set, but we try to set ourselves apart. So we offer something that maybe the others don't. We're now, thanks to the World Congress Center, the 4th largest convention destination in America, and we rely on large pieces of business to come to this community. Here in Atlanta, Savannah relies heavily as well. And so we just ask you to keep in mind that, whether it's written in a very technical sense, and I know it will be, and I appreciate the hard work that goes on in this room. It's rather impressive what comes out of this room. But the average person out there is more in the perception mode than they are in, the legalese.
Mr. Caldwell.
I have 2 questions, Mr. Chairman, if I might. One in relation to what was going to be my first question, but I'll now save it to the second. What I want to know, sir, are you indicating that if we were to pass this law, and particularly as it came out of this subcommittee of this judiciary yesterday, that it would hurt the business community in the state of Georgia? That's either a yes or no question.
Yes, sir. We have gotten calls from customers who tell us if this law passes in the form they saw. Now, it's gone through a couple of iterations. They haven't seen the one that came out last night. Frankly, I haven't yet either.
Do you know where those customers are from or what state?
All over the country. These are national meeting planners who actually move pieces of business. So they may have 20 associations, each with 20,000 person conventions, or they may have a 5,000 person convention that'll just take over one hotel.
Do you know where the Super Bowl was last year?
Frankly, I don't recall, but those are on a selling cycle that go 5 to 7 years out. Okay, he knows.
Yes. Phoenix, right?
Yes.
Right, and they almost lost the Super Bowl, but the governor vetoed the bill, and that's how they kept it.
No, sir. You got 32 states. You got Oregon, Idaho, Montana, Arizona, New Mexico, Texas, Oklahoma, Kansas, Missouri, Illinois, Wisconsin, Michigan of all places, Ohio, Pennsylvania, and all the southern states except Georgia, to include Florida, which has got to be one of the biggest tourism states in the nation that have this. My question to you, have they been hurt?
I don't know the answer to that on a national basis, but our bureau director handles that. They do the national selling. My job is inside the confines of the state. But they're happy to give you that, Judge, so that you can know those data points if you'd like.
Representative Evans.
Thank you, Mr. Chairman. Thank you,
Sprouse.
Mr. Sprouse, thank you for being here.
two questions, if I might. The first one is, it's relatively new. Y'all heard that Indiana just passed a RFRA law. I was wondering if you had had a chance to look at the Washington Post article that is talking about how the NCAA is already raising concerns about how that might affect the tournament and future tournaments coming to Indianapolis, and does that highlight some of the concerns that you have if a bill like this were to pass in Georgia, our ability to get and keep an NCAA tournament?
It does exactly, and I have seen that story.
And my other question is, do you know, it's been mentioned that there are 31 other states that have RFRA laws, but are you aware, and I'm not, but I believe that there are some of these states that have specific provisions that prevent discrimination in their law, so that even though they have a law that protects religious liberty, it truly just protects religious liberty and does not discriminate. Do you have any idea how many of those other 31 states have laws that protect against discrimination?
It's my understanding it's about a half that have actually adopted the RFRA legislation. But
and that may be the reason that they haven't perhaps lost.
Right. And I don't think that anybody in our industry is opposed to protecting the freedoms of expression of their religious beliefs. That is maybe contrary to what people's perception is. And again, I'm here on the actual issue of perception more than the reality. But the perception is that Georgia has been and continues to be a welcoming destination. We want to perpetuate that. We want to invite folks here. We appreciate the leadership of this General Assembly over the years who have expressed the vision that represents why we are successful in the hospitality and tourism business, and we want to continue to be your strong partner. And we want to support when you're looking to strengthen aspects of protecting liberties that are important and inherent. But at the same time, we're here to give you at least a little bit of an appreciation of what we're hearing from customers and the perception that's out there, whether it's real or not. Sometimes these decisions rendered by business planners are made on perception rather than reality, and we felt it was important that you hear that just so you could understand. We're not here to castigate or criticize, and certainly I'm not going to lawyer while I get in the room with this group of distinguished attorneys, but it is an important element that we want you to consider, and we wanted to reflect to you. We've had seven calls this week from customers that are expressing grave concern and have expressed a challenge with whether or not they can book their business here based on the perception with their membership that they represent, and I thought it our obligation to share that with you.
Representative Oliver.
I think I can waive because you have convinced me that hopefully you believe very strongly that perception here is reality. Since there are only about 200 people in this state of 10 million that understand this very dense case law, and the senator is certainly one of them, perception is a reality in salesmanship. Is that true, sir?
And I've discovered in politics, too,
yes.
Over the years.
Thank you.
Okay. Representative Weldon. Representative Kelly.
I appreciate the conversation about perception and reality.
Yes, sir.
And being a legislator, you understand that sometimes the reality of what we do here doesn't match the perception
Amen.
Of what is viewed and portrayed in the papers.
True.
And you talked about the World Congress Center. And the last couple of years we've had some money in the budget. The reality was that money was for parking for the World Congress Center.
Correct.
The perception in my district
is different.
Is that it's for the Falcons. So should I listen to perception when I'm making the decision about the budget, or should I listen to the reality?
Well, the hospitality and tourism industry in Georgia has trusted the judgment of this General Assembly to understand the difference. And
I hope we'll do the same here.
And I think so. The reality is I'm sharing this information with you so that you can be cognizant of it and that you use it in your calculus of making those decisions and understand, as Representative Oliver points out, that sometimes perception and reality aren't measured the same way with us as somebody who is 600 miles away in charge of booking 200,000 convention seats over 10 group business pieces over the course of a year. And I felt compelled to come share that with you so you understand. They're not going to be in this room. They haven't seen any of the legislation. They're just operating decisions based on what their members are telling them and what the perception is. Those few of us who understands how this process works appreciate the hard work you've put in. Last night's meeting that went to 7:30 and the number of iterations. You were working hard last night, sir. But the number of iterations that came out was challenging for almost everybody to keep up with. So I know the outside world is not really as understanding as we are, but I appreciate that diligence, the hard work. I just felt, and my members felt, it was important that you hear from us that we're supportive of everything the state of Georgia has done to create this market and to support this market over the years. Directly affects the state budget. We're spending all these dollars on various things that come directly out of these visitors' dollars, and we feel like it's important that you know when those customers are telling us if they're coming back or not.
I appreciate that.
Thank you.
I'll certainly keep your view of perception versus reality and which one you think is more important when making some decisions up here.
Thank you.
Mr. Fennell, Mr. Spouse, thank you all for coming today.
Thank you, sir.
Thank you.
Mike Griffith. Mr. Griffin, since this is your first time here, there'll be about 3 minutes. We'd ask you to keep it to, and please tell us who you are.
My first time here today.
But welcome, and we're happy to have you. Please tell us who you are and who you're with, and we'd love to hear from you.
Mike Griffin, I'm Public Affairs Representative for the Georgia Baptist Convention. Also speaking on behalf of the Georgia Right to Life, I am their State Field Director. And perception reality. You know, when I was in here about 3 days ago, I did get a chance to testify, and I talked about the verse of Scripture or the quote from Isaiah 1:18, "Come, let us reason together." And I want to thank the committee for the reasoning and the fact-finding that you did yesterday. As Joe Friday would say, the facts, nothing but the facts. And the fact of the matter is there's a lot of rhetoric out there. There's a lot of narratives that are floating around this. And we talk about perception versus reality. Let me tell you that I think the most important perception of this committee and the most important perception of this state legislature is that you don't want to give the perception that you don't care about First Amendment rights. Because Bill Clinton cared, Chuck Schumer cared, Ted Kennedy cared, Governor Nathan Deal cared when he was there, and President Barack Obama cared when he was a state senator because he voted for a state RFRA. And I'm telling you, I think it's an insult to those men to think that they're homophobic or that they're hate mongers or that they're for discrimination or that they're have a preference for one particular religion over another or one particular race over another or one particular gender or another. I mean, this is an issue. It's not about being black or white or Democrat or Republican, gay or straight, Southern, Northern. This is about First Amendment rights. It's about having had those rights brought down to a second level instead of first level, like speech and public assembly and the freedom of the press, because of a Supreme Court ruling in 1990, and then in 93 an attempt to try to restore back to that those rights that we once had with that strict scrutiny, the balancing test, and all those types of things. And it was accomplished. And then in 97 have another Supreme Court ruling that said that the federal government cannot enforce a protection like that on the states. That's what a state needs to do. And that's what states have been doing. And again, if you go back to the facts, it just hasn't proven true that the things that we've heard where the sky is going to fall down if we pass this, that it has actually happened in reality by way of genuine court cases to prove these concerns. I'm not going to read what I read Ted Kennedy the other day, former Senator Ted Kennedy, what he had to say. And of course, he mentioned the fact that this does not create any new rights for any religious practice or for any potential litigant. But I just want to read just what President Bill Clinton said when he signed the first RFRA, just showing you the intent and what they were trying to do. He says, "But let us never believe that the freedom of religion imposes on any of us some responsibility to run from our convictions. Let us instead respect one another's faiths, fight to the death to preserve the right of every American to practice whatever convictions he or she has, but bring our values back to the table of American discourse to heal our troubled land. And we need that now more than ever. And he says, they, the founding fathers, knew that religion helps to give our people the character without which a democracy cannot survive. They knew that there needed to be a space of freedom between government and people of faith, that otherwise government might usurp. So again, back to the facts. Over 30 states, 22 years. I appreciate the hard work and the diligent work that this committee's doing. And you're having to take in all the narratives to make sure that you're doing the right thing. But just like when we're getting ready for baseball now, and you have that catcher back there, and he always tries to make sure that ball comes right into the strike zone. It may kind of come out here a little bit, but when it hits that mid, he brings it back down there. We hear all this, but we got to bring it back down in front of the plate, get the facts, and move forward like that.
Thank you, sir. Representative Evans, is that your button?
Thank you, Mr. Chairman. I'm not sure this is actually working.
Well, let's see.
It is.
That's number 14. How about pull Miss?
Red light's on. Oh, maybe. I just turned it on. It was off in the back, I think. Thank you, Mr. Chairman. There's been a lot of discussion about perception and reality, and you started to speak on that as well. And my question is, and also in light of your recognition of Senator Kennedy's statements about how we're not creating new rights here. So if this law gives no new rights because the Constitution already protects religious liberty, why do we need to pass it simply to give the perception that Georgia cares more about religious liberty than states that don't?
Because it will be reality. It will care. Because it matches what other states have attempted to do and what the 93 RFRA did do, and that's restore back to it that strict scrutiny test that needs to be there. So it's going back to the original intent of the First Amendment. It's not uncommon that you would pass laws commensurate with the Constitution. I mean, we passed laws I helped lobby for it, but we passed, I thought, good gun legislation that Georgia Baptist supported, having churches, at least a part of it that had to do with churches having a choice. But we had a Second Amendment already, but we passed legislation to ensure those rights, that they were not infringed upon, and made sure that they were guaranteed. And so it's not unheard of that we pass legislation that's related to constitutional issues like this, and particularly one that is based on trying to restore something that was lost in 1990. I think it's fitting.
Representative Oliver.
Mr. Griffin, you've been allowed to testify again about these senior Democratic politicians. I heard it yesterday, and I had some thoughts about that. And the reality here, the reality for me, is that what has changed since 1993 for Ted Kennedy and 2015 for those of us today is that there's been a dramatic shift in the law, in the rights, and in my church, and maybe in other churches, with the rights of gay Americans. And the energy around RFRA looks like it relates to a very fast-growing change of the law, which I find a little surprising how fast it's changed, that gay Americans have additional rights today in 30-plus states to marry, and that simply wasn't true in 1993. And the last 18 months, the last 2 years, has been an emergence of a enhanced discussion about religious liberty that directly relates to the enhanced freedoms that gay Americans have. Do you agree or disagree that those two phenomena are
I do
linked?
agree that the narrative is out there, and we're trying to do, as all American citizens, to maintain the First Amendment provisions, regardless of what the narratives or the circumstances are, to maintain a protection for people of faith so that they won't be discriminated. So the bill's about discrimination. It's about people of faith not being discriminated for their deeply held religious beliefs or being forced to have to participate or not be able to do something that they feel in their good conscience. The whole purpose of the First Amendment was to acknowledge the fact that God, not government, is to be, Lord of the conscience, and that government would not exercise that overreach. We have court systems that would take good case law, good statutes like we have here, of which none have proven to carry out the fears, the phobias that have been brought up against this. I mean, having someone testify, as these gentlemen did here today, increase the phobia, I think. If I was concerned about that, I certainly wouldn't say anything. We're trying to pass a law dealing with the ethical treatment of human embryos. And somebody related that to industry, said, oh, they're just going to think we're just a bunch of Luddites, a bunch of rednecks down there. You know, we don't want industry down there. I'm thinking, man, you're hurting it by saying that right now. I mean, you're continuing to talk about it, keeping a narrative that you know is not true. You just keep it going by keeping on saying that. So we
would prefer the business
I
people
wouldn't.
not to
I think they ought to have that right. I'm just telling them their speech has consequences, of which they were concerned about as well. And I think when people who are who carry with it a lot of knowledge and education, such as yourself, would be able to come out in public and say, hold it, I understand that you have these concerns, but you need to not direct them toward this legislation. There may be some other issues that you need to be in order to be more constructive, but this is not what you should be focusing your attention on.
Representative Bruce.
I know we had a little conversation in the hallway, but if not to discriminate, why not allow the language to be specifically put in the legislation that would say you can't use this as a defense against, against discrimination, and that would clear it up. And we keep making reference to these other states. And the truth be told, this is Georgia. And Georgia's not like a lot of these other states, okay? And I can remember some really bad stuff that happened down here since I've been here. So I'm looking at Georgia.
Was it because you came?
I hope not. And if you want an example of it, I'll be glad to give it to you.
I'm being lighthearted,
okay.
But you know we do that every night.
Yeah, I know, but I'm being dead serious.
Go ahead.
Okay, and right now, what you're asking us to do is to allow state-sponsored discrimination. And if that is not what you're asking us to do, then let us put it in the bill showing that that's not what you want us to do. And all these other states that you keep making reference to, several of them, I don't know how many, but several of them have put that in there for the specific purpose of making sure that there's no question that that's not the intent of the bill.
I would give serious consideration if you could show me an example where that happened, and you apparently can't do that.
Well, I can.
There are no court cases citing RIFA as the purpose for creating discrimination.
We're not talking about court cases. We're talking
talking about evidence. We're talking about facts.
We're talking about the reality that I've probably gotten, as everybody else, probably gotten thousands of emails on this. And those that are opposed to it, as was mentioned earlier, their perception of this, their reality of it, is that it is discriminate. That is for the purpose of to discriminate. And if you're saying that is not the case, and I believe that you believe that, but if you're saying that's not the case, why not just put it in here?
Let me give you the second reason then.
Okay.
It's because you don't know what the future is going to be by way of federal, state, or local ordinances that could be discriminatory toward people of faith that they pass. I have a resolution from the Georgia Baptist Convention that was passed in support of this legislation, and in it we state the fact that the Houston mayor, Mayor Parker, subpoenaed sermons that challenged Houston's equal rights ordinance. Well, they have this type of language you're talking about that kind of leaves that loophole in there, which put a lot of pressure on these churches to have to conform to this public accommodation type law. So you don't know what the future may be, and if you and the fact of the matter is you don't want to have discrimination at all. So you can't. I think that there's been enough history to prove that that type of legislation in Texas could have some problems with it in the future.
Any further questions for Mr. Evans? Thank you, Mr. Evans. We appreciate you being here with us today. Thank you very much.
Thank you.
Okay, Tanya Diddy. Ms. Diddy, please come forward. Welcome. Thank you for being with us today. Please tell us who you're with, and we're happy to hear from you.
Okay, thank you. My name is Tanya Diddy. I'm the State Director for Concerned Women for America. I did speak the other day in subcommittee, and so I will be brief in my comments. At the end, I do have my statement that I can pass out, so I won't read it all. The only thing that I wanted to bring up, and it's what I brought up in subcommittee the other day, had to do with, and we can talk about perception and reality. Last year, when this legislation, when there was an attempt to pass it, and it didn't pass, there was a lot of coverage in the news and articles, so I went back and read. I tried to do my homework to see what the opposition of this legislation was. And a big piece of it, and it was mentioned earlier, had to do with this being, if this legislation was passed, that it would be a perception that Georgia would not be an attractive state in which to do business. So I went out and decided, okay, Governor Deal has spent the first 4 years of his governorship and forward promoting Georgia as a business state, and he has done a phenomenal job bringing businesses to this state. And so I went out and looked at the types of businesses. I didn't have to look very far, and I found several businesses just that either are expanding in our state or have chosen to move to Georgia. Travel Sky, Technology, Caterpillar, Baxter International, Mercedes-Benz. And so when I went out and I looked at either their press releases or news articles of as they were moving into Georgia or as they were expanding, and I couldn't find any evidence in any of their comments that the reason they moved to Georgia is because we didn't have a state RFRA. They came here because it was a good place to do business. I went out and looked in the surrounding states. I looked in South Carolina, I looked in Tennessee, I looked at some of the businesses that they've brought in, and they have a RFRA. And it seemed to me that that their economies are very stable, and that they didn't suffer any economic harm by bringing in businesses with their RFRA. So I think Georgia is a good place, and I think that this bill will not do any harm to the reputation of Georgia. Just as a person of faith and in representing my members, we ask that you pass this piece of legislation as it was passed out of subcommittee yesterday. There was a lot of give and take, and I agree that we support the legislation as was passed out of this committee. We believe that religious freedom is the first. It is the first freedom. Excuse me, the first freedom, and it is the bedrock of all of our liberty. And we just ask that you protect and restore back to what was taken away through a series of Supreme Court amendments, and that you give Georgians that protection as other states have now with their RFRAs. Thank you for your time.
Ms. Diddy, thank you for coming today. We
Thank
appreciate that. Jeff Graham. Jeff Graham. Is there a Jeff Graham here?
Yes.
Oh, please, Jeff, thank you.
Behind the pole.
Okay, hiding behind the pole. Jeff, thank you for being with us today. Mr. Graham, please introduce yourself. Tell us who you're with.
Thank you, Mr. Chair. I appreciate the opportunity to speak with you today. My name is Jeff Graham. I'm the Executive Director of Georgia Equality. Our mission is to advance fairness, safety, and opportunity for gay and transgender Georgians throughout the state of Georgia. I am concerned about the passage of Senate Bill 129 as it currently stands, and the chilling effect that it will have on the over 300,000 gay and transgender citizens of our state. There are currently no state or federal laws that provide us protection against discrimination in the workplace, in housing, or in accessing public accommodations. However, there are currently 59 cities and counties in Georgia that have enacted some local form of local ordinance that protects at least some in our community against many of these forms of discrimination. And we as a community need these protections. In the only broad survey done of the LGBT community in Georgia, 45% of people said they had experienced some form of workplace discrimination or harassment in the previous year, and that 48% had experienced some form of harassment or discrimination in a public establishment. Should this bill pass, those municipal protections could be rendered meaningless if the person denying the service, harassing the coworker, or firing the employee claimed that they did so out of a religious conviction. And as has been stated a little bit earlier in the hearing today, those states that do have RFRA laws on the books, all but one of them do have some form of statewide civil rights protection. Georgia is one of only 3 states that does not have statewide civil rights protection. That is an important thing to keep in mind as you're looking at balancing religious liberties with personal freedoms here in Georgia. Please understand, I come to you myself as a person of faith, someone who studied religion and considered a career in the ministry when I was younger. I applaud your efforts to ensure that diverse religious views are heard and protected in this state. That is important. However, as a gay man, I can assure you that the vast majority of derogatory comments I have heard and the primary arguments used to prevent my community from achieving legal equality are rooted in what people profess to be their religious beliefs or their personal interpretation of a few selected biblical passages. This is not to say at all that all people of faith and religious beliefs are biased against gay and transgender people. In fact, in a statewide survey of Georgia's community, Georgia's LGBT community, over 2/3 of respondents said that they held their own personally strong religious beliefs. Furthermore, the number of religious denominations and faith traditions that have openly embraced gay and transgender people and have taken public stands in support of LGBT issues has dramatically increased over the past 30 years. However, there are still many denominations that continue to struggle with this issue and many that openly condemn sexual and gender minorities. Yes, protecting religious liberties is important, but so is protecting the rights of minorities, who have a proven history of discrimination and bias directed towards them. Without any provision in this bill that makes it clear that that discrimination is not the intent, you can be sure that this is how it will be used. That is why conferences and corporations outside of Georgia are beginning to speak out about their concerns. I think it's also important to point out that we have worked with a network of over 200 clergy members who have signed a letter denouncing the bill. As Rabbi Peter Berg said in that letter, if enacted, we believe this bill would give some the right to harm others, and to do so in the name of religion. It could have a broad range of harmful consequences, from discrimination against gays and lesbians to individuals claiming religious rights to ignore the laws we already have on the books. I ask you to please, if you consider passing this legislation forward, please do so with very clear intent that this bill not be used to discriminate or harm anyone else. Thank you.
Thank you, Mr. Graham. Thanks for coming today.
Final thing.
One second. We did have a question. Representative Beskin.
Thank you. Mr. Graham, you mentioned that of all the states that have RFRAs, only one does not have a statewide protection for civil rights for gays?
Mississippi, I believe, is that state, yes.
Okay, so all the other 19 states that have RFRA have a statewide civil rights protection for gays?
Correct.
Okay.
No, I'm sorry, only 5 of them specifically include protections for the gay and transgender community. However, in states that do have a statewide civil rights law, I do believe that has been used by courts to balance claims of RFRA against claims of discrimination.
So I'm confused now. Let's say there's 20 states as of today that have a state RFRA.
Yes.
Of that 20, how many of those states outside of their RFRA statute have a statewide protection statute for gays and lesbians, a civil right protection?
Sure. It's 2 separate issues.
Right.
One is that all but one of them have a civil rights statute to begin with. Georgia has no statewide civil rights statute.
Right.
So that's the first point that I was trying to make with that. Then beyond that, specifically with claims of discrimination towards the gay and transgender community, there are 5 of those states that offer some form of that have include sexual orientation and gender identity in their non-discrimination civil rights protections.
Within their RFRA or in their statute?
Within the civil rights statute.
Okay.
Since Georgia does not have a civil rights statute, that's why
Correct.
we feel that we would need to specifically talk about this bill not being used to support discrimination, so that there could be that balance there, that clear understanding.
Okay, thank you.
Chairman Weldon.
Thank you, Mr. Chairman. There's one state with that recognizes gay, lesbian, bisexual, and transgender folks as a protected class.
I believe that it is 5 states, sir.
Oh, 5. Okay. What are those states?
I do not actually have that sitting right in front of me.
Okay. And do you have copies of those cases that you mentioned that?
I do, in fact, have some copies of cases of how RFRA has been used.
Okay. Thank you.
Okay.
And the way this statute is written, and I'm been on this committee, this subcommittee, and on this committee. This bill, if let's hypothetically, if there was an issue where a GLBT person that had been discriminated against on the basis of someone exerting their religious freedoms, this is going to come before judges of this state. And I'm a lawyer in this state, and I've practiced in this state pretty from one end to the other. And those judges are elected by the people of the state, citizens that in their circuits. And I frankly, I trust the citizens to, particularly in Catoosa County, to elect good folks. And throughout the state, to elect people that reflect the views of their circuits. And I've just never I've never met a judge that I thought was not sophisticated or able to handle these issues. And this statute, as it provides, someone can assert their religious freedoms. I believe that a judge could put together a remedy that would be non-discriminatory to anyone, but also see to it that the intent of the statute, the ability of someone to be able to recover for being trampled upon by government as a result of their religious beliefs, where it could be worked out. There's nothing in the statute that intentionally or I don't even think there's anything that could be construed to a judge in this state in a compelling way that would allow someone to discriminate against another person as a result of us passing the statute just like it's written.
Where my concerns would be in those 59 municipalities that have some form of protection right now. If people felt that upon passage of the state RFRA, that would open the door for them to ignore those local prohibitions against discrimination, then the discrimination might go forward. And that's where my concern is, that the discrimination could take place. And if it truly is not the intent to do that, I would ask this panel to find a way to insert language to make that clear to the judges and clear to the public that is not the intent of this bill.
Well, that would mean that we'd be creating protected classes under this statute, wouldn't we?
There has been a number of amendments that were offered yesterday. There was language that was included in the findings on the Senate side that attempt to address this. Certainly you can do it by creating classes, and I will certainly let you know that that would be my ideal. However, I recognize we don't all get our ideal in life. I think that it would be a common sense compromise to at the very least make it clear that this bill is not about discriminating.
Well, this bill is about discrimination, and it's about discrimination with respect to religious liberties, correct? And this bill, the only class that it creates is all citizens of the state of Georgia, right?
Could you give me perhaps an example of how you felt that that somehow someone interacting with a gay or transgender person, employing a gay or transgender person, or serving a gay or transgender person in their business, how that would be an infringement upon someone's exercise of religion?
Well, you know, I'm the one that gets to ask the questions here, and you one that gets to answer the questions.
I was just trying to better understand the question, sir.
I tell you what we're going to do right now. I'm going to ask. This is an important issue. I'm going to ask the senator to come up. McCoon, come up and right here in this microphone. Go ahead, Judge. Go ahead, Judge. Go ahead, Judge.
Sir, I got just a couple of questions because I might have misunderstood. You said that right now there's no protection under Georgia that would protect the civil rights. Is that correct? Was that your statement?
Under state law, that is correct. Under state or federal law.
Isn't the highest law in the state of Georgia the Constitution, regardless of what a statute is? Isn't the Constitution the highest law we have?
That is my belief. I am not an attorney.
Doesn't the Georgia Constitution virtually mirror the federal Constitution concerning civil rights of all types and prohibits discrimination?
But to clarify that, there is a federal civil rights statute because, unfortunately, we do have a history.
Constitution. Does not Georgia's Constitution virtually mirror the United States Constitution? And those two are the highest. For the U.S., the Constitution is the highest regardless of what statutes are. And in Georgia, the Constitution is highest regardless of what statutes say. Don't they virtually mirror one another concerning discrimination and to prohibit it?
It certainly states that. However, there have been numerous cases where people have lost their jobs, have lost their housing, or have been refused service at establishments out of the perception that they are gay or transgender. Before that, we had a history of racial discrimination, ethnic discrimination. That's why we have passed additional laws on both the state and federal level to recognize that. Georgia has not adopted a statewide civil rights statute, and that currently leaves members of the LGBT community unprotected.
Senator McCoon, come right up here if you would. Did you want to address this issue?
Yes, Mr. Chairman. I think it's important for the committee to understand, first of all, that of states that have a statute on religious freedom restoration, there are only 2 that I'm aware of that include any sort of so-called anti-discrimination language, and those are Texas and Missouri. As I told the special subcommittee yesterday, I believe it was yesterday, maybe it was Tuesday, Texas right now is trying to move forward on a constitutional amendment that does not include that language because of many unintended consequences and problems that have been created by having the anti-discrimination language present in the Texas Religious Freedom Restoration Act. I said before, I'll say it again, if the intention is to provide every citizen in this state with strict scrutiny of their free exercise claim, then you do not want to delegate what religious freedom is going to mean depending on what hundreds of different local governments have to say on the subject of what they consider to be anti-discrimination language. I think that would create a lot of problems. There was a question earlier, and there are really 2 points here that I think are important on this subject. One was Representative Oliver asked an earlier person that was testifying about states that have same-sex marriage. There are states that have same-sex marriage alongside Religious Freedom Restoration Acts, and they're issuing the marriage licenses. Has not been a problem. South Carolina, Virginia, Pennsylvania, Illinois, North Carolina, Mississippi, Arizona, New Mexico, Washington, Idaho, Indiana, Michigan, Wisconsin, Minnesota, Oklahoma. They're not having a problem. Now the other thing that I wanted to point out, you heard from the very first person that testified up here, they made it very clear that they believe that the bill in front of you is the same as the bill that was passed by the Arizona legislature last year and vetoed by Governor Jan Brewer. Nothing could be further from the truth. And the reason I bring that up, it certainly goes to the perception issue, but Arizona's had a Religious Freedom Restoration Act on their books since 1999. So if a state legislator who was seeking, he was very clear about it, he wanted to make the RFRA allow people to deny service. That's what he wanted to do. And so he, I'm sure just like we do here, he went to his legislative council and they said, well, in order to do that, you're going to have to amend the existing Religious Freedom Restoration Act. Well, what should that tell us? It should tell us that the language before you doesn't authorize refusal of service and it doesn't authorize discrimination. So for all of those reasons, the committee, I believe, should follow what the subcommittee has done and stick with the federal language that has 22 years of case history at the federal level and over a decade to 15 years of case history in 30 other jurisdictions. Thank you, Mr. Chairman.
Representative Evans, did you have a question?
I do, Mr. Chairman. Thank you. First, I wanted to answer Representative Weldon's questions about which of the states have the protection for against discrimination based on sexual orientation. That's Connecticut, Illinois, New Mexico, Rhode Island, and Utah. But my question is, and either for Mr. Graham or for Senator McCoon, isn't the concern, well, actually, I guess this would be to Mr. Graham, isn't the concern that, not that we don't have learned judges who are thoughtful, but that if we don't give them alongside a RFRA, not necessarily, since we don't have a law already that is a civil rights law, they wouldn't have anything to balance against. And within the question, I want to address Senator McCoon, who said in all these states where there's RFRA, they don't have any specific language in the law that addresses non-discrimination, but those states do have separate laws that address those issues, that do allow those judges to balance. And that's what we're looking for here. Am I right?
Yes, ma'am. That's exactly correct.
Thank you.
Go ahead.
I would completely disagree with that characterization. I mean, the fact of the matter is that judges in Georgia are able to balance the compelling governmental interest that is presented by a government seeking to enforce anti-discrimination measures against the religious exercise claim. I mean, that is the entire point, is to allow the judge to make that decision. If we want to try to anticipate each and every case that a judge is going to hear and then try to legislate the outcome, we just shouldn't move forward on this bill. I mean, the whole point is to empower the judiciary to apply the strict scrutiny standard, and that's what the language in front of you today does.
But Senator McCoon, don't we have to give the judge language that where he can find a compelling governmental interest? The judge just doesn't get to decide on his own what is a compelling governmental interest. That's the job of this body. And until we tell him that we as a legislature have decided that Georgia believes that there is a compelling governmental interest in preventing discrimination, he can't find that.
The Federal Religious Freedom Restoration Act and the majority of the statutory state Religious Freedom Restoration Acts do not define compelling governmental interest. So, in fact, they do leave it to the courts to make that determination.
But if they have a civil rights law, then they have done that. They have given the judges the language that says, we believe, because we've passed a civil rights law, that there is a compelling governmental interest in preventing discrimination, and that's what we don't have.
No, I would disagree with that. I mean, there's an entire body of law that we have at the state level and at the local level. Judges can choose by interpreting those laws what are compelling governmental interests and what are not, and that, it's not contained in the majority of state RFRAs. There's no reference to civil rights laws. There's no command to the judiciary of how they are to determine what a compelling governmental interest is. It's left to the court to decide.
Representative Rutledge. We're going to stop right there, and you'll have plenty more time. All right, I guarantee this committee, we always get more time. Mr. Graham, thank you so much for coming today. We appreciate you being with us. Mr. Garland Hunt. Pastor Hunt, we appreciate you being with us today. Please tell us who you're with and introduce yourself, and happy to have you. Thank you.
Thank you so much, Chairman Fleming. I am senior pastor of the Father's House Church in Norcross, Georgia. Also the executive vice president of the Fellowship of International Churches. I'm born and raised here in Atlanta, in southwest Atlanta. I went to Douglas High School, Mount Vernon Baptist Church, which is a prominent black church in this city. I attended Howard University, undergrad and law school. I support the Religious Liberty Bill, Senate Bill 129, and specifically I want to say to mirror the Federal Religious Freedom Restoration Act. And I've written down my comments, not because I can't preach to you, but I wanted to be very specific, because every word I've written is very, very serious. I think this is a very serious bill. I simply am asking you to vote in favor of the U.S. Constitution, First Amendment, and the Religious Freedom Restoration Act of 1993. As you know, protection of the religious freedom on the federal level simply states that the government will not intrude upon my freedom unless there's a compelling state interest. I was just devastated when I realized that Georgia, the state where I was born and raised, would not afford me the same protection that the federal government and 32 other states afford their citizens. I'm very concerned and afraid as a pastor and a Georgia citizen that my freedom to live and speak my conscience can be overruled by a simple law or ordinance that may deny me my inalienable right given by God. I voted for my elected officials to help protect my religious freedoms. Many of my forefathers have died to protect freedom of expression, freedom of religion, and freedom of speech. As an African American pastor, I'm deeply burdened at the thought that my religious freedoms may be denied at such a low threshold. As you know, the impetus of the civil rights movement was fueled in the black church. Without this religious freedom bill, the voice of the black church may be silenced, and the voices of African Americans of faith can be denied by the government without strict scrutiny standard in Georgia. This brings me great concern that my most precious right could be denied so simply. I'm also highly offended when my efforts to protect my right of religious conscience is made analogous to racially charged discrimination accusations. This is blatantly untrue characterization of this bill. I resent the inference that the bill has ill intent. The Georgia bill is to protect my inalienable right given by God in the First Amendment and codified in the Religious Freedom Restoration Act. This is about protection of my liberty, not discrimination. Let the government have the burden of proof. That's all I'm asking, to, if they're going to deny my religious freedom, to have the duty of proving compelling state interests as required by the First Amendment and the federal RFRA. I love this state as you do. In closing, please do not turn your backs on the faith community in Georgia. Please do not gut this bill by making this a statewide civil rights anti-discrimination bill. Leave it to another bill or local municipalities or civil councils. Please pass this bill to mirror the federal RFRA. Scripture says the Lord is our judge, He's our lawmaker, He's our king. Thank you.
Representative Bruce?
I'm sorry, I missed your name.
Garland Hunt.
Mr. Hunt. Your statement, you said that you are protected under federal law. Did I not hear you say that? Mm-hmm. Okay, so what will this bill give you that you don't already get under federal law?
In the case of City of Byrne versus Flores in 1997, the court struck down that portion of RFRA that applied to federalism, to all the United States. And what they said in that case, which is really clear, that Congress was not going to tell the states how they should protect religious liberty. So then they required of every state to pass their own RFRA. Okay. So what we have here is a federal standard that if it was a federal court case, I would have the protection of RFRA. But if it's a Georgia court case, I would not have the same protection because the threshold would be very low to prove government intrusion in what I believe.
Okay. But does not the federal government also provide protections for civil rights, for just all of the stuff you get in the First Amendment?
Mm-hmm.
Let me finish.
Sure.
All of those things that are protected by federal law, why not, and I've asked this of others, why not put those same protections in this bill so that they balance? The federal law says that we will not discriminate based on all of the various reasons that are there, and that balances out, the protection of religious freedom. Why not do the same thing here? Why not balance it out and have something that says that they're not going to discriminate? I don't know how old you are. You know, I can't tell by your hair, but
No, that's great, man. I'm glad of that. I'm actually 56.
But I'm sure you have relatives, you know, ancestors, as do I. And,
Yeah.
you know, my hair, I'm a little older than you probably, that have been discriminated against. That have been told to ride on the back of the bus.
Absolutely.
That have been told they can't sit up in, you know, in the restaurants and all these other things. We have that in common. And that's why those federal laws were put in place. Why not balance it here in Georgia so that we have those same protections to protect against religious discrimination, but also against all these other forms of discrimination? Why not have both?
And Representative Bruce, that is an excellent question. I'm so glad you asked me. Because those protections, first of all, First Amendment stands by itself. RFRA, the way it was set up, the Religious Freedom Restoration Act of 1993 stood by itself. But then you have the 14th Amendment. Then you have all the amendments that dealt with civil rights legislation. Those were separate bills. In many cases, in the cases that we've been talking about here, the municipalities, the city governments have set up their own anti-discrimination type bills. But in this case, on the federal level, there are civil laws, but that's not for this bill. What I'm looking for this bill is my protection, the same balance of how the government must prove for their intrusion into my religious freedom. They have to prove, and it's all about what they prove. Strict scrutiny means compelling state interest. So I'm not, in this particular bill, it's not proving whether or not we need anti-discrimination in Georgia. What this is proving is that what is there in the First Amendment and thereby the Religious Freedom Restoration Act is also applicable for me here in Georgia.
Representative Kelly.
Thank you, Mr. Chairman. I just want to try to clear this up because we are having a discussion about whether our state has a Civil Rights Act or not. But it's my understanding, and I want to see if you agree with this, Pastor Hunt, that the federal civil rights law filters down and applies to us here at the state level as well. And that originally, up until 1990, the First Amendment provided strict scrutiny for 4 kinds of rights: speech, the press, religion, and our right to assemble. Then in 1990, they carved out religion. So in 93, President Clinton signed into law the Federal Religious Freedom, which restored strict scrutiny. Their intention was to apply it to both the federal government and federal claims and state claims. However, then in 97, you've already talked about the case there, the Bournes case. They said that no, that this doesn't go all the way down to the states. And so that's why so many states after that started taking up this measure. Is that kind of your understanding, that the federal civil rights law still filters down and provides the same protections for our citizens under the federal civil rights action? And so that any additional on this legislation would be unnecessary?
Absolutely. I would even say, particularly as I think about further amendments, as it talks about, it says no state shall. It's very clear in the civil rights laws, as well as even civil rights legislation, the whole idea of it was that it would be utilized particularly for the states. And that was with those times the federal government would deal with that. And that goes over to the whole questions of federalism as such. But right now, they carved out, just like you just said, they carved out religion and reduced the standard. So the only way we, as those that have religious freedoms that are based on the First Amendment, the only way in Georgia for us to have the level of proof in the courtroom about government intrusion is by having a compelling state interest based on strict scrutiny. That's simply all we're asking out of this bill. So please don't gut it by making it a bill that it was not intended to be.
Pastor, thank you for coming today. We appreciate it. You want me to bring him back? Pastor, if you come back up, Ms. Evans have a question. She got mad at me for cutting her off earlier, so I'm not going to do it again.
Thank you, Mr. Chairman. Pastor, my question is, I didn't have any question. That's why I'm sure that the chairman was not trying to cut me off. It's just my button was late because it was the very last thing that you said that spurred my question. You said, please don't gut the bill. If, in your mind, there are already protections for, I don't agree, but you are saying that there is already a place where a judge can find a compelling state interest against discrimination. If that is true, why would adding language to prevent discrimination in this bill gut the bill?
Well, the purpose of the bill is to protect my religious freedom based on First Amendment. So you have to look at the core of the bill, which you guys do all the time, and I just appreciate how you distinguish it in terms of what the purpose of the bill. I'm not saying to you, based on any other bills that you may later on pass, but in this bill is for the protection of my religious freedom in the state, not only just as a Christian, but also other faiths, that they can express that in their own religious conscience. But the question is, what does the state have to do in order to intrude upon whatever all of those religious freedoms are? So that's very simply all that we're saying. In terms of the anti-discrimination, civil rights laws, all those are appropriate. Listen, like Representative Bruce said, I mean, I'm from a community that had to have that, else we were be in the back of the bus. I'm saying right now, if we don't do something, those people of faith are going to be in the back of the bus.
But so I think that we agree then, a law that would prevent discrimination would not get in the way of this bill.
Not in this bill. What I'm saying, keep this bill like RFRA, because that was the intent of the federal government, signed by President Clinton, President Obama, former Congressman Nathan Deal. All of them supported that in that purpose. I'm saying keep the purpose pure for this bill.
Thank you, Pastor. We appreciate you coming today. Thank you very much. Anthony, and I want to say the last name correct, Christ. Anthony Christ. Mr. Christ, thank you for coming today. Welcome. Please tell us who you are and who you're with, and happy to have you.
Well, thank you. So my name is Anthony Michael Christ. I teach at the University of Georgia. I research the intersection of LGBT rights and religious liberty. I've been extensively published on the subject, and I'm here to testify in my individual capacity and not on behalf of the university.
And what subject do you teach at UGA?
So I teach, right now I'm teaching legal theory. I've taught civil rights history. I've also taught Introduction to U.S. Government, which I should say my students love the fact that you all have mandated Georgia politics. So they love that part of they're doing it tomorrow. So
undergraduate?
Undergraduate. I've also extensively done a lot of lecturing at law schools, and that's primarily where I publish in law journals and law reviews.
Welcome, and go Dogs.
Go Dogs. So first and foremost, I support the principles undergirding the Federal Religious Freedom Restoration Act. I've worked to balance religious liberty in state civil rights legislation across the country. However, SB 129 fails to achieve an adequate balance because it permits free exercise challenges to civil rights laws and ordinances. Important municipal protections have been safeguarded in Georgia localities against LGBT discrimination in housing, employment, and public accommodations. And the public has been assured that this legislation will not undercut those norms. However, a number of SB 129's grassroots proponents have explicitly stated that they intend to use this RFRA bill as a vehicle to gut civil rights, including an exemption for civil rights laws and ordinances, as other states, including Texas and Missouri, have done, would better calibrate this legislation. Now, I believe that LGBT inclusive non-discrimination laws meet RFRA's standard to trump potential free exercise claims. However, it is still an open question as to whether state courts in Georgia would agree with me. Even if my instincts are correct and RFRA litigation arising from LGBT civil rights enforcement is resolved in municipalities' favor, it will have been done needlessly at considerable taxpayer expense. There is a real non-hyperbolic risk that the threat of costly litigation alone may deter municipalities from expanding non-discrimination protections. The current draft of the legislation prohibits or notes that RFRA shall not be used as a defense to child abuse or neglect in order to head off its perversion by bad faith actors and to give comfort to victims. It rightfully reinforces what every reasonable observer fully knows. No court would permit that. We are given similar verbal guarantees with respect to civil rights laws. Georgians targeted for animus and discrimination should similarly enjoy that refuge in the text. In addition, I know you all wanted case law, so I've come with cases. A number of RFRA decisions rendered in state and federal courts are worthy of your consideration, and I have citations for you all if you want them later. The 6th, 7th, 9th, and 9th Federal Circuit Courts of Appeals have all addressed whether federal RFRA applies to suits between private parties. The 6th, 7th, and 9th circuits have found that RFRA does not apply to lawsuits where the government is not a party. There's also an unpublished summary from the Fifth Circuit Court of Appeals that seems to presume the same thing, that RFRA doesn't apply between private party lawsuits. Only the Second Circuit has taken a contrarian position and did so in the limited situation where it believed the government could have been a party. It has, however, retreated from that holding in subsequent dicta. The New Mexico Supreme Court, following these federal courts' lead, declined to apply RFRA to civil rights action between private parties in which a defendant was found to have engaged in invidious discrimination. These rulings, when paired together with existing state statutes, significantly shield civil rights laws from improper litigation. A civil rights exemption is necessary to import this civil rights shielding principle from federal case law into Georgia law. Municipal governments enforce non-discrimination laws in Georgia, and Georgia law prohibits localities from creating private rights of action. Thus, the only way to guarantee interpretations of a Georgia RFRA to reflect the similar principles in federal case law is to add an express civil rights exception to RFRA's application. In short, and in conclusion, we must not jeopardize civil rights law, discourage municipalities from expanding non-discrimination protections, or otherwise embolden anti-gay animus. I urge you to reconsider this legislation as it is currently drafted and work to find ways to advance the civil rights of all Georgians together. Thank you.
Thank you, Professor. We appreciate you coming today. Next will be Jim Grubiak and Rushi Patel. Y'all want to come together or separately? Okay. Cities and counties working together. Okay. Thank y'all for being here with us today. Thank y'all for being with us today. Go ahead and introduce yourself and welcome.
Thank you, Mr. Chairman. My name is Jim Grubiak. I represent the Association of County Commissioners of Georgia. And with
Rushi Patel with the Georgia Municipal Association.
First of all, we wanted to make it clear that we're not here to address the merits of the legislation. But if indeed the legislation does pass, we have some suggestions that deal with the practicality of implementing the legislation. Certainly there's a possibility that a county or a city will pass an ordinance or make a decision that might adversely affect someone's religious rights, or at least some person's perception that their rights are being infringed upon. We think it's probably likely to be unintentional when that happens, but it certainly could happen. So we think it's advisable that the bill be amended to provide a notice period where the government would be notified before litigation about any problem that a citizen perceives. We believe the notice period would allow government and persons asserting their rights under the Act to resolve the issue. Keep in mind, local governments are not some remote governmental entities that are not susceptible to local discussion. They're the governments closest to the people. So we think that notice period would be very effective in allowing the government and the individuals that feel aggrieved to work out their differences.
Question, Mr.
Yes,
Ray, did you come with language proposed?
We do have some suggested language, but we understand there may be some language available in the committee itself.
I wasn't sure.
Yes, sir. Yes, sir. So,
all right.
So, I mean, it seems like this body would, in summation, it seems like this body would want to encourage the resolution of disputes before litigation. Rarely is it ever a bad idea to encourage the savings of tax dollars, and we think it would make sense to have a notice period. So,
thank
you. And to further elaborate what Mr. Grubiak was saying is we don't want any of our cities and counties to infringe on anyone's religious rights. Religious freedom is obviously the First Amendment of the Constitution of the United States for a reason, or part of it at least. That said, if any city or county does accidentally or intentionally infringe upon religious freedoms, I hope we would all agree that the goal should be to end that infringement. That should be the main and first goal. And if we can end that infringement quickly without litigation, which would save taxpayer money, that would be an ideal situation. And I want to present an example of a situation that arose recently in the city of Avondale Estates. Back in 1970, the city of Avondale Estates had a zoning ordinance change that required churches basically to be on 3 acres of property. kind of a silly ordinance when you think about it right now. And you fast forward to recent times, and as you may imagine, they have a new council in recent times, and a church tried to place their property, and the city had issues with that, and there was some potential for litigation. But what was interesting about this was that the district court noted that the city never knew that there was an issue, and that a simple phone call from the plaintiff would have resolved the case before large fees could have been charged, because the city didn't know that their ordinance did that. Sometimes they just miss things. The court found that the plaintiff's counsel spent almost 3 months preparing to file a complaint and motion for preliminary injunction, during which time they amassed over $55,000 in attorney's fees. As soon as the suit was filed, the first notice that the city had, the city consented to not enforce the ordinance, and soon after repealed it. Importantly, I think the church's counsel attempted to argue that notifying the city before filing the suit would allow the city to, quote unquote, stick it to the church by changing its zoning ordinances and limiting the church's ability to be located on the sought premises. The district court, however, was not persuaded and held that the declaration was neither credible nor persuasive, because the city could just as easily have stuck it to the church after litigation was filed. The court found that the, quote, only entity to suffer real prejudice in such a case would be the plaintiff's counsel, who might lose the opportunity to accumulate a large fee. And so that is one big reason why we would strongly encourage y'all to consider adding some notice provision in there. Certainly state government and local governments may mess up from time to time, but sometimes that's accidental. And if they don't know about it, having that notice could help them prevent litigation and solve the issue much quicker than litigation would ever do.
Thank you, Mr. Patel. Mr. Weldon, you have a question?
Just briefly, I appreciate you gentlemen being here and representing the ACCG and the GMA. This bill only applies to government, correct? Is that your understanding of the bill?
That's my understanding of the bill.
And the way that cities and counties or governmental entities can take care of this is if I don't believe a court would hold that a city or county or a municipal organization would be liable for an infringement upon a religious freedom unless as applied the application of the ordinance or law or rule regulation would infringe. Is that what you're getting from this bill here?
I'm not sure if I'm following your question completely.
Okay. Well, they would have to impose either not allow somebody to exercise their freedom of religion versus they have the rule or they have the ordinance that if it was applied or enforced against a church or individual, that it precluded them from exercising their freedom of religion. Correct?
That would be my understanding.
An as-applied approach would be the way. Okay. Thank you.
Mr. Cole.
Gentlemen, I may be a little bit confused in your analogy when you was talking about the city of Avondale Estates that they didn't know about. Aren't they charged with knowing their own law if they're the ones that passed it?
The situation in Avondale Estates was actually much more complicated than that. There was also the situation where the church was locating without building permits and without the requisite fire inspections and things like that. So the situation was actually much more complicated than the zoning, first of all.
Well, I'm just talking about the zoning because that's the part that you got to. I understand if they don't have building permits, you can do whatever, but shouldn't they know their own law?
They should, and the interesting thing is that the zoning law they had said you have to have 3 acres for the property, and on its face they might have looked at that and said we don't see anything at issue with that until somebody brought the issue forth to them.
And then my second question would be, the citizens, everyday citizens that work in a factory or wherever, they're charged with knowing the law because they certainly don't write the laws. But if they violate one, they're charged with they shouldn't have violated it. And I guess my analogy is it's a city law and the city made it. We shouldn't reduce the city to a lower standard than a citizen is, should we?
I agree with you. I think what we look at here, though, is we're looking at a law that's affecting general law that's applicable to everybody. So the same could be applied for this legislation.
We're running short of time. Appreciate
you,
your
sir.
comments on this, and they'll be given consideration. I will call on next Paul Smith. Mr. Smith, come forward, please. Give us your name. You represent any group.
Thank you, Mr. Chairman. My name is Paul Smith. I'm the Executive Director of Citizen Impact. We're a faith-based organization. I represent Christian schools, elementary and high school, as well as several hundred churches across Georgia. And I'm here today to ask for support of the bill as it came out of committee without the so-called anti-discrimination language that has been talked about. I don't want to be remiss and not thank the members of the committee for spending many hours carefully deliberating this legislation. I've talked to some of you individually, and I believe that many of you are really listening thoughtfully, and I am trying to express sincere thanks for that. 2 points I wanted to make have already been just slightly touched on, so that should help make my comments briefer. Christian schools and that I represent, but faith-based schools in general, have historically been permitted to hire people, or I should say only hire people that adhere to their faith, to their sincerely held religious beliefs. They're not permitted to discriminate on the basis of race or gender, but when it comes to religion, they're permitted to hire those folks who only believe what the school believes. I would be surprised if anyone on this committee believes that a Jewish school should have to hire a Muslim, or be compelled to hire a Muslim. A Christian school be compelled to hire an atheist. They've always been permitted under state and federal law to make that distinction. If anti-discrimination language is added to this bill, then they will no longer have that option. Furthermore, faith-based ministries have also been required of their employees to adhere to a morality clause. That is a statement that they will live according to the faith of whatever particular religion it is. Again, some Christian colleges, who I don't necessarily represent, but one here in Georgia has already come under fire for requiring that of their employees. Again, if you add that anti-discrimination language, then essentially we no longer have a religious freedom bill. I also wanted to mention, as has been touched on, the case in Houston where Texas has apparently similar anti-discrimination language as some are suggesting that Georgia adopt. I flew to Houston to stand with the 5 pastors who were subpoenaed for their sermons. These pastors merely wanted to encourage a vote on accommodation law that was passed by the city council rather than by a vote of the city of Houston. And nothing short of intimidation tactics were taken against these pastors. Why do I characterize it that way? Because all their sermons are available online. Why would they have to be subpoenaed for those sermons? But they were subpoenaed for their sermons, text messages, and other communications with their parishioners. That is very troubling. Pastors should have the same freedom. People of faith should have the same freedom that's guaranteed under the First Amendment to petition their government for the redress of grievances. And yet, apparently, there's some that don't believe that, or at least they want to use intimidation tactics to frighten pastors into not participating in their free exercise that way. So, again, I'm here today to ask you to support the bill without the non-discrimination language.
That's a couple of questions, Mr. Potts. I think Ms. Oliver, you're first.
Senator McCoon also mentioned religious schools. In my district, there's the Torah Day School, Jewish school, and an Immaculate Heart Catholic school within a few blocks of each other. And why is that government action if they choose to hire or not hire Jewish or Catholic employees?
Because of government non-discrimination laws.
I don't think that is accurate, but I think that's a. You think that if we pass this,
with that language,
okay, we probably
I'm
have.
not a
I think we
lawyer,
have a disagreement on that. I can't figure out whether it's government action.
I have to rely on.
He's
on
expressed his
attorneys.
opinion. Is what you're doing.
Well, based on what attorneys have told me.
Okay. And next I have, I believe, is you waive. Okay, excuse me, Mr. Fleming.
Thank you for coming today, and I believe your point is if a local government adopts an anti-discrimination ordinance and it instructs these churches what they will have to do, and we have this anti-discrimination clause in this RFRA bill that's not in there now, then there will be no religious protection for that church as far as these clauses as he's mentioned. In fact, Georgia law will be worse on that position than if we didn't have a RFRA law at all.
Case about.
We're going to have a discussion among the committee
Okay.
on amendments as we get to it. We appreciate your indulgence in waiting for us, Mr. Smith. We appreciate you being here too.
Thank you. Thank you for your time.
Ms. Jane Robbins.
Thank you, Mr. Chairman. I am with the American Principles in Action, which is an organization that is devoted to restoration of our founding principles. I live in Stone Mountain. I've submitted my testimony, which I think y'all have in your pack, and I'm not going to say any of it because I'm not going to go that long. I wanted to mention a couple of things. One, on the question of discrimination. Why can't we just put in discrimination language? Well, and I think that Mr. Smith talked about some of the problems with that, and there are other problems with that too, and the one I was thinking about was in the Hobby Lobby decision, which was decided under federal RFRA. Now, if the federal RFRA had the discrimination language, the discrimination exception, the way that's been suggested, then presumably the government would have said, well, you're discriminating against women by refusing to pay for abortion-inducing drugs. I think that's a ridiculous argument, but there are a lot of people in the country who don't think that's a ridiculous argument. And the case could have come out very differently if we had a judge who didn't think it was a ridiculous argument. And so if I owned a business, a closely held business, and I didn't want to pay for abortion-inducing drugs because as a Catholic I cannot do that, I would have to shut down my business. So that is one problem that I think would be created by including that sort of very broad language, because discrimination is not something that means the same thing to everybody. What's discrimination to me might not be to you, or vice versa. So it's very difficult to do that. But I just wanted to tell one brief story about a friend of mine who is a registered nurse, and she read something in the paper a couple of weeks ago. It was a particularly troubling piece in the paper about what would happen with this bill if we pass this bill, that then people would start refusing to treat AIDS patients. And she read that, and she's been a nurse for 30 years, and she said, she's a devout Catholic. She's a devout supporter of this bill. She said, I have treated AIDS patients with love and compassion for 30 years. And the suggestion that if the law changes, that I will stop doing that is deeply offensive to me. I do that not despite the fact that I'm a Christian. I do that because I'm a Christian. So I think that the claims that people of faith in Georgia, that Georgians of faith alone among all people of faith in the country are so mean-spirited that they are just lying in wait to mistreat their fellow man and their fellow woman, and they'll do that with this bill unless we keep them on a tight leash. It's just not fair. It's deeply offensive. And so my organization supports the bill as it came out of the subcommittee yesterday. This language has stood the test of time, and I hope that you will pass it this way.
Thank you. Mr. Weldon, do you have a question? Real brief. All right, I'll take a
Do
brief one.
you feel like you've been discriminated against because of your religion, or did you and your friend have the discussion that you're being discriminated against as a result of your religion and being put into someone who would apparently discriminate against another person as a result of their AIDS or whatever condition they're in.
Well, if I had a broad view of discrimination, the way a lot of people do, I would say, yes, that's discriminating against me to say that I would do this kind of thing or she would do this kind of thing. The point is, discrimination means different things to different people.
Right. Thank you, Ms. Robbins. Appreciate your time and patience coming today. I believe the last we have will be Robert Potts. Is that correct, Mr. Potts? Please come forward. You bring Ms. Galloway with you.
Thank you, sir.
Good afternoon,
Thank
Mr.
you.
Chairman, members of the committee. My name is Robert Potts. I'm the Executive Director for Georgia's Faith and Freedom Coalition, and to my left is Ms. Virginia Galloway. She's the Southern Region Director for Faith and Freedom Coalition as well. Our organization does support this legislation, and we urge this committee to consider today's testimonies and support the legislation as well. As you have heard by now, 32 states, including now Indiana, have passed similar laws or have similar protections already on the books to protect our citizens from government overreach into our daily lives. Many have asked why this bill is needed. Whether a person is a Christian, a Jew, a Muslim, an atheist, or whatever they choose to believe in, their practice of that religion and belief does not stop after an hour's service on a given day. It is an everyday practice, 24/7, 365. Everyday hardworking citizens deserve to have their religious liberty and freedom protected from government overreach. The most well-known case, has been mentioned many times by now, is the RFRA case being used nationally, of course, in the case of Hobby Lobby and their desire not to provide certain health care desires as it violated their conscience. This law protected Hobby Lobby from government overreach into their business and their decisions. Our court system says that we are innocent until proven guilty, and we believe it's time to get back to that standard and stop the government from revoking the rights of individuals until the person can hire an attorney and take the state to court to regain their rights, as has been the case in instances across the nation and the state in religious persecution. There have been many provably false claims about this bill. We commend the other side for creativity, but not for truthfulness. We have heard that businesses will not set up shop in Georgia if this law passes. Georgia was rated the #1 state in which to do business in 2013, as we're all aware by now. You know what turns away companies from states? A lack of quality candidates for jobs and a bad tax environment. Certainly not the state protecting the religious freedom of all individuals. We have asked continuously for anyone to show us one business that has left a state because of this law. Not one example has been given. Where religious freedom is protected, people prosper. Around the world, you'd be hard-pressed to find a country that has no religious freedom but peace and prosperity. Countries that protect religious freedom, in general, experience less armed conflict, higher income, higher level of education for women, better health outcomes, and perhaps most important of all, other personal liberties are more secure, such as freedom of the press, freedom of speech, economic liberty, and freedom of travel. This is good public policy. I rarely agree with President Obama, and we all know by now he voted for this law when he was in the Illinois State Senate, and I agree with him in that vote. I'd like to take this opportunity to thank the subcommittee for improving this bill yesterday. We're grateful for the hard work you did and how the substitute bill now reads. It accurately reflects the intent and language of the federal RFRA. Thank you for your time. Once again, I urge the committee to pass the substitute Senate Bill 129 out of this committee and send it to the floor of the House. Thank you.
Thank you, Mr. Potts. And Ms. Galloway, it's always a pleasure to see you. We're at the end of the public input at this time. The chair is going to take, at least a 5-minute recess. I think everybody's been sitting for a while. Let you get up and stretch your legs, get some water if you need to. We're coming back and be under consideration the bill and any amendments. Everyone come back to the committee room and resume your seats. The chair will start proceedings again. Is there any more committee members outside? I told them as I was coming through. All right. I'm going to have the door closed and make it secure. So if you're coming in, do so. I'm going to have them close the door and make it secure. All committee members back, I assume. All right, thank you. The posture at this time is the chair is going to bring forward the bill, which is Senate Bill 129. I'm going to recognize, as far as reading out, we have amendments. We have amendment, and I'm going to read out the order in which the amendments will be considered, which is following the progression within the bill. I have the first amendment, unnamed, AM 292417. This is the definition of the compelling governmental interest. Whose amendment is that to be? Jacobs. Is Jacobs here? Just in time, Mr. Jacobs. All right. Second one we got, the The next progression of amendments I have is one from Roger Bruce. Is Roger in the room, Mr. Bruce? All 5 minutes. All right. Next I have is a Welch amendment, LC 296650S.
It doesn't have a number. It's the short.
I know, it's just, that's why I read the amendment number. Amendment LC 29.
That's the bill number.
There's a number on there? Okay. At line 42, excuse me. The next one will be the Willard Amendment, which is the 1 AM 292415. The next amendment I have is the Powell Amendment, which is begins with saying amend Senate Bill 129 by inserting immediately following line 44 the following. And the last one I have is the Powell Amendment, which reads amend Senate Bill 129 by inserting on line 64 on page 3. That's the last one. The chairs will rule all amendments have to be in writing to be considered. There will be no oral statement of amendments. We'll keep the clarity of what we're dealing with. This, you got a button, Mr. Weldon. Yes, sir. Mr. Bruce. Oh, Mr. Jacobs, excuse me.
Mr. Chairman, just a parliamentary inquiry.
State your inquiry.
Will the chair, if there is a brief amendment to an amendment, would the chair entertain that?
The chair will entertain an amendment to an amendment, since that is not a statement of an amendment.
All right, thank you.
Mr. Weldon?
I'll waive that. Answer my question.
All right. Yeah. So the posture we have before us is the subcommittee substitute, which is LC 296650S. The chair will entertain a motion as to that bill. Motion is do pass. Is there a second? Is there a second? All right. We have a motion, a second. We will go forward with any amendments. The chair's position is we will have the progression of amendments, as I talked about, going down through the bill. We've asked for Senator McCoon to sit with us, and if there's any questions to be asked by committee members, they will make those requests through me, and I will determine if it's a question to be submitted to Mr. McCoon. We have the First Amendment, Jacobs Amendment, AM 292417. State your amendment and explain.
Certainly, Mr. Chairman. The amendment is AM 292417. It would amend lines 15 and 16 of the bill by substituting the definition of compelling governmental interest that is set forth on the amendment for the definition that's contained in the bill. What it does with regard to the existing definition is that it would add the words and protecting persons against discrimination on any ground prohibited by federal, state, or local law. And then just to briefly make a statement on the amendment, I have friends who are in favor of the bill, and I have the utmost respect for them. But as you know, I represent a district, and we're each here to represent our districts. I have received many emails about this bill, both from inside and outside my own district. I will say that the emails that I have received from inside my district are overwhelmingly opposed to the bill, and they are overwhelmingly opposed in particular to the bill on the basis that the constituents who have emailed me and contacted my office are concerned that it would enable discrimination. I take at face value the statements of the proponents that they do not intend discrimination with this bill. But I also believe that if that is the case, we as the General Assembly should state that expressly in the bill itself. That is what the amendment does. I hope that proponents can respect the fact that having won 5 elections in my community with over 66% of the vote each time in a row, that we are all a reflection of the communities and the districts we represent. This is what my constituents want me to do. This is what I want to do as their legislator, and this is what I think we should do as a General Assembly.
All right, do we have a second to the Jacobs amendment? It's been seconded. We have discussion on the amendment. Mr. Weldon.
This discussion on the amendment.
Yes, sir.
Okay. The discussion on one thing I want to say about this is that this amendment includes federal law and local law that would be imposed in a state, in a general bill that's going to be enacted throughout the state. So we're taking whatever the federal government gives out, and we're taking whatever any local municipality gives out. And how we're going to deal with colliding federal and local laws that are opposite, and then we try to impose these throughout the state.
Your questions to the presenter?
Yes, sir.
Ms. J, do you want to respond?
I mean, I would only respond by saying I don't believe that federal, state, or local laws collide with the express language of the bill, and if the intent is to not discriminate through the bill, then we ought to, regardless of the source of law, be that federal, state, or local, be willing to say that expressly in the bill. I mean, for me, in order for me to support allowing this bill to move forward from this committee, and I have not made a final decision as to how I will vote on the House floor, but in order for me to support allowing this bill to move forward from this committee, I think we should state it expressly in the bill.
I'll recognize next Mr. Fleming.
Mr. Chairman, I have a few questions, but the first one is to the author of the bill, and that is this amendment. We have seen or heard significant testimony over the past couple of days, and to my recollection, the subcommittee defeated about 3 amendments yesterday that would have done something similar. But my question is, in regards to the hiring practices of churches, the certification of adoption agencies, and so forth, what would this amendment, in the author's opinion, do to the RFRA Act and the cases that may be brought under forthcoming?
You want to ask that question
to Mr. McCoon, Senator McCoon.
All right, to Mr. McCoon. You want to respond, Mr. McCoon?
Thank you, Mr. Chairman. I believe it would completely undermine any claim that the religious institution or the person of faith would have. And again, as I've said earlier, I believe discrimination, much like the amendment the subcommittee considered yesterday using the term civil rights, these are very elastic terms. They can mean different things to different people. I think it creates an exception that will ultimately swallow the rule. And again, I think that adoption of it essentially negates the purpose of the bill.
Mr. Chairman,
got a follow-up. Let's get each individual. You push your button. I'll come back to you. Mr. Weldon, your next question.
I'll waive.
Waive, all right. And we have over here Ms. Evans.
Thank you, Mr. Chairman. A follow-up to Senator McCoon, if I could, based on Representative Fleming's question. The answer that I heard from Senator McCoon was that it would undermine the bill, it would swallow the bill. Those are very conclusory statements, and I'm hoping that the senator could maybe give us an example of what he thinks, what he wants his bill to do that it would not be able to do with the language that Representative Jacobs has proposed.
You wish to respond to that?
I'll be glad to.
All right.
I think it's hard to answer that question because I don't know what hundreds of local governments will do. I don't know what a court will do with this language. I think that as has been stated earlier, the issues with employment at religious schools, I think there are a number of other contexts where that would come up. But I believe strongly that by having this language, which again, it's kind of ironic. People have said this bill's a solution in search of a problem. I would say the amendment's a solution in search of a problem, since even the opponents, even the handout you were provided earlier today, does not cite a single reported opinion anywhere where discrimination has been authorized by a court interpreting the Religious Freedom Restoration Act. So I think for all those reasons that the amendment should be defeated.
Thank you. Mr. Fleming.
Mr. Chairman, here's a specific question for the author and for the proponent of the amendment, Chairman Jacobs. Some churches in this state, Baptist churches, I'm Baptist, believe that in certain leadership positions of the church, those are positions for men only, for example. My Baptist church is not one of them. We have women deacons in my church, but I do know some that aren't. If one of those churches exists in the city of Atlanta, and the city of Atlanta passed a local anti-discrimination ordinance like you have allowed them to in this amendment, then that church was challenged on that belief that a man needed to be in a certain leadership position. They would not be protected, would they not, under a RFRA law, because you have created an exception in it by allowing whatever the local government passes as a discrimination law not to be protected by RFRA.
I'm going to let Mr. Jacobs respond, then the chair may respond.
Well, I mean, the question contains a hypothetical that, I mean, I don't know that there is an answer to the question, because the question contains a hypothetical regarding an ordinance of the city of Atlanta that does not exist. So in that regard, I'm not sure I have an answer to that question. I would sincerely doubt that the city of Atlanta has any interest in legislating with regard to the operation of any church or synagogue within its city limits or any religious school. But I mean, the question itself is based upon a hypothetical ordinance that you know, where the substance of that ordinance is not contained in the question. Therefore, there is no answer to the question.
The chair will exercise personal privilege in the sense that I have represented a church organization for over 30 years, Seventh-day Adventist Southern Conference, which is headquarters here in Decatur, Georgia. Used to be in Atlanta on Hightower, and I have, in representing them, had cases where this was an issue, and the defense that we have is that the separation of church and state, the courts will not entertain matters that relate to the practices of a religion as a means of controlling what is done as far as hiring, employment, whether it be by race, sex, or otherwise. I mean, it's been cases I've handled at this point of information. Well, employment or otherwise. I'm saying they they recognize the representation of what the churches do as far as their practices is not something the courts will answer or allow redress for changing or limiting or prohibiting. We've got Mr. Weldon, you have another question?
Yes, Mr. Chairman.
Yes, sir.
That would be the entanglement clause of the Constitution.
Yes, sir.
And then, but in the standard, I believe, for that discrimination is whatever the state sets it at.
No, I think it's the federal Constitution is what controls it.
Right, and the standard, the compelling state interest, or intermediate scrutiny, or rational basis.
I never answered that way.
It's the rational basis, and this bill right here, Mr. Chairman, I believe, raises that to compelling state interest, strict scrutiny.
Okay. Mr. Kelly, you have a question?
Yes, sir, Mr. Chairman. Maybe I'm just looking to get some clarification here. And I know we were just talking about churches and understand the argument you made. But what about a situation like a religious school, like a college, a religious college that wants to have a morality clause that says that they don't believe it's aligned with their faith that two people live together before marriage, and that's not consistent with their belief? And what if a local government said that you cannot discriminate on hiring for any reason? And at that point, would that religious college be forced to go against their beliefs simply because they've chosen to locate and create and serve a community for years and years? And I want to say that I'm going to oppose this amendment because I remember a couple years ago when I first got up here, we had a bill, and I don't even remember which one it was, but someone who I respected a lot of his guidance up here to the legislature, our majority whip, Ed Lindsey, said that there's certain things that the state finds so important that we preempt local governments from doing because we don't want them putting things through the back door that we won't let through the front door. And I think this amendment would do exactly that.
Well,
and that's why I'll be opposed.
That may be the basis of another bill next year for that point. No further discussion. The chair will call the question on the Jacobs Amendment. Are you wanting to speak to it again? One last time.
And earlier I was asking questions. Now I'm going to make a statement, Mr. Chairman, on the matter of discussion. This is the amendment which will gut this bill. This is the amendment, the catfish amendment as we call it, that will make the bill not worth passing. And if this amendment is attached to it, Mr. Chairman, I will not be able to support final passage of this bill because the exception this creates swallows the rule. Therefore, I would ask my Republican members of this committee not to do something which is going to cause several of us to have to vote no on final passage of this bill. The subcommittee rejected this 3 times yesterday, and I would ask the rest of the Republicans on this committee to stand with us so that we can pass a real RFRA bill in Georgia, because if you vote for this amendment, we will not be able to.
All right, we're going to call the question. The question is the adoption of the Jacobs Amendment. Everybody understands the amendment, has in front of them. All in favor, raise your right hand. I'm going to count them off. 1, 2, 3, 4, 5, 6, 7, 8, 9. Count as 9. All opposed, raise your right hand. 1, 2, 3, 4, 5, 6, 7, 8. The motion carries. Jacobs Amendment. Next one we have is the Roger Bruce Amendment. Mr. Bruce, are you back here? What's your push your button? I think you're corner there.
Given the outcome of the last,
pardon me?
Given the outcome of the last one, mine is probably not.
You put aside the Bruce Amendment then. Next we have is the Welch Amendment. You want to speak? Parliament inquiry.
Mr. Chairman, I'd like to be recognized for a motion to table the bill.
Motion to table always takes priority. We're at the point of taking a motion to table. There's no discussion on the motion. All in favor of tabling, raise your right hand. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16. All opposed. Motion carries.
Thank you, Mr. Chairman.